So I'm not mentioning any matter. Constitution bench had pronounced the decision in Cox and Wings. Small request for taking the appearance on record because inadvertently the advocates over.
No problem. Give it to the court master.
So great. So
Your Lordship, we had sent in an email for the mentioning of the matter. It's an eviction.
Don't worry. Have you already sent it yesterday?
Yesterday morning, we had sent in.
Everything has been dealt with last evening. There's no email lying unattended, but I'll check in the afternoon. Just meet Mr. Since we are in a CB, anybody who has any problem, just talk to the registrar listing. He's here. I'll issue instructions at lunch itself.
My lords, if I may say, my lords, I have emailed today, my lords, for the urgent mentioning, my lords.
It's all right. He's here, man. That's why he's in the court right now. I'll pass orders at lunch.
Please, my lords.
Puneet.
Please, my lords. I appear in IA number 23729 of 2023 on behalf of the Assam Sankhya Lagu Sangram Parishad, which is basically the Assam minorities struggle forum. And I also appear, my lords, for an individual case which should not have been before this bench, but there is a reference. So my request is please detag that.
What is that about?
An individual person who was declared to be a foreigner. Somehow that bench. So that is. I'll give the number. That is 0.15 today. Fatiman Nisa. My submissions, my lords, are in volume 2, page 173 to 179, and volume 2B.
Can you just say that again? Volume 2?
Page 173 to 179, and volume 2B, 23 to 30. I will confine myself largely to my one pager, which is in volume 2C, the first page. Please.
Volume 2C will go to your one pager.
Please, my lords.
Let's see what you have said.
Please, my lords.
Yes.
My lords, just a prelude before I begin. My lords, I've been privileged somehow to work on citizenship issues. And your lordships had sent me to talk to people who had doubts about citizenship to Shaheen Bagh. And my request, my earnest request out here is, my lords, that your lordships are called upon today only to judge the validity of 6A, the constitutional validity. My lords, taking a cue from what the Solicitor General said, I am not going to speak too much about what happens thereafter, hereafter, and all that. Because, my lords, my experience has been that any word with regard to citizenship, which is said even slightly here and there, has consequences far beyond one state.
We have made it very clear we are dealing with the validity of Section 6A.
Please, my lords.
Now let's see your one pager.
My lords, citizenship of India is the right to have all rights guaranteed under the Indian Constitution. The provisions of Part 2 of the Constitution were framed by the Constituent Assembly only for defining Indian citizenship, and the crucial words are at the commencement of the constitutions. This definition of citizenship was necessary in order to define eligible voters to elect a new parliament. That was the crucial thing, my lords. At that point of time, we were a new nation. We were a nation that had suffered a partition. There was a question as to who was an Indian and who was not an Indian. And therefore, the constitutional architecture of Part 2 was that we would define only at the commencement who is a citizen. Thereafter, that last one, Article 11, left the field open to Parliament to do what it thought fit in the circumstances. The situation also had to take into account migrations due to partition. The Constituent Assembly therefore limited their definition for the commencement and give full powers to Parliament to define citizenship, grant it or take it away. The first Parliament therefore enacted the Citizenship Act 1955 to regulate citizenship. Well, it's just a couple of dates. Firstly, the date of 19th of July 1948. Why was it chosen? If your lordships were to go to volume 4, page 359, 3599.
3059.
3599, volume 4. Dr. Ambedkar's response.
Instead of reading it, just tell us if you can just make the point.
The point simply is,
So
Dr. Ambedkar
in
said
the Constituent Assembly.
in the Constituent Assembly, Dr. Ambedkar said that, look, we have brought about an ordinance with effect from the 19th of July 1948, which would put in place a permit system. Lordships would recall from the arguments prior that those who had left India and gone across the border, they needed a permit to come back for resettlement. That resettlement date, after the 19th of July 1948, they needed this permission. And that permission was very difficult to get. This, however, applied largely to the western border. On the eastern border, there is Mr. Iyengar, who at page 3672 makes it very clear to the Constituent Assembly that the permit system was not to apply on the eastern border. And for good reasons. There was a substantial number of Hindus who still remained in what was erstwhile East Pakistan, who may have wanted to come over, who had not yet come over, and it was a continuing process. Among the Hindus who later came over was the first Law Minister of Pakistan, Jogendranath Mandal. Mr. Mandal, my lords, died in poverty, but he had several crucial interventions, and the most important was that he got Dr. Ambedkar elected to the Constituent Assembly from Bengal. And once that portion went over to East Pakistan, Dr. Ambedkar had to be re-elected from Bombay, and that's how he came on to head the drafting committee. So, my lords, there was a fluidity in identification of Indian citizenship. While on the western border, it was reasonably clearly drawn. On the eastern border, it was, as a matter of constitutional history and drafting, kept deliberately fluid. So if I can now revert back to my note. The second submission, my lords, is that Indian citizenship is not ethno-nationalist. It's not based on language, religion, or culture. There is no superior or inferior citizenship based on ancestry of any type. This court should eschew any statement that may ever unintentionally be judgmental of such claims, especially in the emotive areas of India's northeast. For example, my lords, this very year, a seemingly innocuous statement in a tax case ended up in having consequences in Sikkim, my lords. The learned Solicitor General did appear there, and I just will pass on the order, my lords, for your lordships' consideration. Your lordships will see that it was a very, very I'll just give it probably just 1 minute. Take his hand over. Solicitor. If your lordship sees page 3. We think it just and proper and in the interest of justice to correct certain phrases in paragraphs 10A and 77 of the judgment by making the following correction. The sentence, therefore, there was no difference made out between the original inhabitants of Sikkim, namely the Bhutia Lechas, and the persons of foreign origin settled in Sikkim, like the Nepalis or persons of Indian origin who had settled down in Sikkim generations back, stands deleted. Lords, this was, people from Sikkim were entitled to a tax exemption. The question was, who all were citizens of Sikkim? Even an innocuous sentence saying that there was no difference, then, my lords, had huge emotive consequences. And, lords, I say this with some experience, particularly when I went to Shaheen Bagh, was that people resent greatly when their Indianness is questioned. We are all Indians. And to borrow an Americanism, we may have come on different boats, but we are in the same ship.
July 1948 actually is
Please.
the date of the introduction of the permit system.
Yes.
I was actually just looking at 3599.
Yes, my lords.
Just let's actually read it because nobody had read it to us.
Please, my lord.
Learned brothers will also have the benefit of that.
Please, my lords, if your lordship.
Just and then we'll be done. The other things you have orally told us. I've also got.
Please, my lords.
3599.
3599.
This was not Constituent Assembly debate.
Volume
This was a debate in connection with what?
My lords, with regard to citizenship itself, if your lordship sees the earlier pages.
This part of the Constituent Assembly debate?
Yes.
Okay.
Please, my lords.
Just that part, I'll
Please,
show you. You can read that one
Yes.
middle
Then
of
I
page.
come.
This permits us. You need not read the whole para. Okay, all right. You can read. Just about 10 lines down. This
my lord.
permit system was introduced from 19
This
July.
provision had to be introduced because the government of India, in dealing with persons who left for Pakistan and who subsequently returned from Pakistan to India, allowed them to come and settle permanently under a system which is called the permit system. This permit system was introduced from the 19th of July 1948. Therefore, the provision contained in Article 5B deals with citizenship of persons who, after coming from Pakistan, went to Pakistan and returned to India. Provision is made that if a person has come on the basis of a permit issued to him for resettling or permanent return, he alone would be entitled to become a citizen on the date of commencement of the Constitution. I may say, sir, that it is not possible to cover every kind of case for a limited purpose, namely the purpose of conferring citizenship on the date of the commencement of the Constitution. If there is any category of persons who are left out by the provisions contained in this amendment, we have given power to Parliament subsequently to make provision for them. I suggest to the House that the amendments which I have proposed are sufficient for the purpose and for the moment, and I hope the House will be able to accept these amendments. So that, my lords, is why the date was chosen and the architecture put in, that in the beginning we have to decide who are our citizens, who will then be voters, who will then participate in the general elections. Lords, curiously, all this thing about permits, and if you went over to Pakistan, had also consequences on facts of each case. There was a gentleman who went to school in Bombay. Then thereafter, he went off to the US for further studies. He then had property in Bombay. His family had property. He wanted to hold on to it. He asserted that he was an Indian citizen. His family was in Karachi. He became a minister out there. And then when questions came about his citizenship, it was as late as November 58 that he withdrew his petition before this court to assert that he was an Indian citizen. The gentleman's name was Zulfikar Ali Khan Bhutto. And my lords, he chose a citizenship whose Supreme Court then probably did not do him justice. Be that as it may, it's an oddity. There were all kinds of people.
All right,
Please,
now,
man.
I think we'll conclude there because we have to finish. Right.
Just 2 minutes, my lords. I've pointed out Mirajkar, my lords. And I would also urge your lordships, my lords, that any large-scale decision which may have an inadvertent consequence of statelessness.
That you have made your point.
Please, my lords.
Thank you, Mr. Hegde. Now, who's next now?
Please, my lords. I'm
Thank you.
grateful.
May it please, Mr. Yes, I'll be very, very brief because everything has been argued in extenso. Because I appear for Assam Gan Parishad. I have filed IA number 74061 in writ petition number 562 of 2012. And my IA is in volume 3, page 1634.
Mr. Das, IA number?
It's 74061
2020.
of 2023 in writ petition civil number 562 of 2012.
And
we've filed our one-page written submissions.
brief submission is at page 2. Right?
2 and 3, volume 2C. So I just have two broad submissions.
Yes.
One is that we are signatories to the original Assam Accord. Two, I fully support the learned attorney and the learned solicitor. And Milods, I just wanted to point out one judgment which has not been cited on general versus specific, which is 2014 8 SCC 319. And I just wanted to lay emphasis on just two paras.
What is the name of the case?
The name of the case is Commercial Tax Officer Rajasthan versus Binani Cements Limited. And I just wanted to point out only two paras. Paras 36 and 47. Only to answer your lordship's query, why Assam, why not Bengal, etc. Para 36, my lords may kindly have. The maxim generalia specialibus non derogant is dealt with in volume 44.1 of the 4th edition of Halsbury's Laws in England at para 1300 as follows. The principle descends clearly from the decisions of the House of Lords in so and the Privy Council in Baker versus Edgar, and has been affirmed and put to effect on many occasions. If Parliament has considered all the circumstances of and made special provision for a particular case, the presumption is that a subsequent enactment of a purely general character would not have been intended to interfere with that provision, and therefore, if such an enactment, although inconsistent in substance, is capable of reasonable and sensible application without extending to the case in and para 47.
So you are saying that 6A was a special provision
I'm
intended to deal with a specific situation.
I'm deeply obliged.
Got you.
Deeply obliged.
Thank
I'm
you,
grateful.
Mr. Thank you, Mr. Amal.
Great.
Who is next now? Mr. Siu Singh?
Yes. But I'll rather than give your lordship numbers, if my lords just say it takes, but in
No, we've got the number.
two-
It's 117074 of 2000, 117074 of 2019.
and 181511 of 2019. So my written submissions are in volume 2, page 119 to 172.
Volume?
Volume 2, page 119 to 172. And the one-page note is at page 4 of volume 2C. And there are just three main points which I'll very quickly go over. The first is the learned Attorney General in para 7 of the note. My Lord may just note this. Learned Attorney General in para 7 of the note and the learned Solicitor General at pages at paras 1 to 6 of his written submissions in volume 2, page 3. Volume 2, page 3, paras 1 to 6. And the learned Attorney General, there was a note, para 7 of that, have relied on Tilok Chand to say that that delay in this case should not be a complete answer. This, your lordships ought not to even enter into the so-called merits of the challenges, because this is not a case where there are petitioners who are merely seeking assertion of some right of their own. Here, the petitioners are seeking assertion of a right which would strip away other people of rights which have accrued to them over a 27 or 30-year period. Today it's 40 years, but in 2012, when they filed the petition, it was a 27-year period. And there are constitutional rights have accrued, which are the right to have rights. People have become citizens by naturalization, because 6A is a sort of species of naturalization. They have become citizens by birth, etc., and all that is sought to be stripped away.
Have we got what's
Now-
the next point now?
No, on this point, what is very important, and that this is where I come in. Tilok Chand, the argument was that they cited the judgment of the learned two-judge bench in Assam, Sanmilita, to say that Tilok Chand ought to be reconsidered. What the two-judge bench failed to notice was that Tilok Chand had been followed by another constitution bench in Rabindranath Bose, which your lordships will find in volume 5 at page 1255.
Volume 5, page 1.
Volume 5, page 1255, Rabindranath Bose.
1970, 1 SCC, 84.
It's in my one-page note in para 2.
You mentioned.
Now, what is important is that in Rabindranath Bose, an express plea was made that Tilok Chand needs to be reviewed and was rejected by the Constitution bench. So my lord may just straight away come to page 1266 of volume 5. I'll just show two short passages.
Not necessary. We are make a note of it. Just tell us the paragraphs. That's all.
Para 31 at page 1266 of volume 5 and para 32 and 33. In para 32, there's an express plea.
At page?
Page 1266 to 1267 of volume 5.
Fair enough. So the plea for review has been also rejected by a CB.
By a CB and para 32 is that express plea for a review.
Fair enough. You made the point.
And the CB goes on the basis of accrued rights of others. Here the seniority rules were challenged. They said that people have now benefited from seniority, that they have moved on, and therefore Article 32. So there's a categorical statement of law by the CB that where third-party rights have accrued, Article 32 will not be invoked and will not be entertained.
That if we accept the point which has been made on your side is that if we accept the submission of the petitioners, it will also result in statelessness because and the solicitor also pointed out that the joint communique of Sheikh Mujibur Rahman, the then Prime Minister of India, stated that Bangladesh assumed responsibility for those who entered India post 25/3/71.
71, yes. Now, so this is one part I submit was that it's not open.
Next point now.
And if at all they were right, that would have to be referred to a 7-judge bench. So that's not really open.
Next point.
Now the next point is, Millards, that one of the principal arguments really when they filed these petitions was that the Assam Accord has been picked, there's a picking and choosing, and only 6A has the part of Assam Accord which has been implemented is only that which was enacted in the form of 6A, and the rest of the Assam Accord has not been implemented, leading to supposed large-scale migration into India and what they call infiltration and so on and so forth in the state of Assam. Now, the petitioners themselves prevailed on the court while making a reference to your lordships in the 5-judge bench to continue to entertain the petition and to implement all the rest of the Assam Accord. And between 2014 and 2021, in fact, in large measure, all the other provisions have been implemented. All the border fencing, the searchlights, etc., the beefing up of security on the borders, and the supposed weeding out of the infiltrators.
Now, if you can go to your point number 4, Mr. Singh. There's something much more important which we wanted to explain from your note. This is okay that they've.
I just want to point out for the affidavits that this will come on affidavit. So my lord may just note that
now we are in
No, I only want to tell your lordship.
Interveners now. We have to get on with the rejoinder.
No, absolutely.
Now go to point number 4. Just explain that because that's a conceptual point nobody else has made.
Yes, Lord. Section 6A does not violate Article 14, but is rather a step forward to legalize the determination of foreigners as per the Assam Accord, signed with stakeholders who led the agitation, and definitely does not violate Article 14 rights of the petitioners. This section may be treated as a version of citizenship by naturalization under Section 6, read with the 3rd schedule. Now, let's
just read it and so that we'll be able to understand.
The only difference being that whereas Section 6 did not apply to countries in the 1st schedule, with the creation of Bangladesh in 1971, the said exclusion became meaningless as far as its citizens were concerned, and a special provision was needed to deal with them. And just as grant of citizenship to any person under Section 6 does not violate Article 14, grant of citizenship to a class of persons under Section 6A does not violate the right to equality as well. The point in citizenship by naturalization is based on continuous residence in a country. In our case, it was 7 years originally, then it was made into 11 years. So a person who is not an illegal and is residing in a country for a particular period can then ask for citizenship by naturalization. Under Section 6, read with the 3rd schedule, the 3rd schedule sets out the conditions. Section 6, it is granted to people. Now, 6A is a sort of species of that because it is again based on continuous residence here. But what happened was, because Pakistan in 1955, Pakistan had East and West Pakistan had a very special status where India. So the 1st schedule said that Section 6 said that naturalization will not apply to citizens of those nations named in the 1st schedule. That 1st schedule is now repealed. But it was, so basically, citizens of East and West Pakistan were not eligible to that particular route. Now in 1971, Bangladesh is now no longer part of Pakistan. It is a friendly nation. It has it has never had even one day of history of enmity or war or anything with India. It's no longer Pakistan. I mean, we have the reality is that once Bangladesh was formed in December 1971, it has been, in fact, we were the midwives who helped to give birth to that nation. And we have had friendly nations throughout. So now, conceptually, that exclusion really didn't, it was there in the statute book. Bangladesh was still a sort of a successor to.
That was their argument, actually.
But being in the statute book, but that bar really didn't apply. So what was done, but the political settlement in the Assam Accord, because there was massive agitation, etc., was that you have you create another section where there'll be a form of naturalization to recognize those displaced persons or refugees who have come from Bangladesh and who have lived for a long period of time in India. And therefore, that it is sort of, it's one species of that. So I'm only saying, just as 6 is never tested on 14, which person is granted citizenship by naturalization, another person can't say, why have you granted it to so-and-so under 14? Same way, I'm saying that conceptually, 6A should be tested on the same anvil. That merely because you're granting it to one class of people doesn't mean that there's a violation, certainly not any violation of the petitioner's rights. Violation might be claimed by another class who are denied citizenship. And other people say, I'm identical to Mr. Singh, why am I not given citizenship when he's been given it? But can somebody else say, why are you giving it to him and not to others? A person who is not eligible for it. So this is just the slight thing. Now, the last thing, I'll only give your lordship the page numbers and I'll close that.
Yes.
The para 5, 6A did not encourage further infiltration, but rather created a fetter. The state's population growth post-1971 compared with the rest of the country does not support the argument that it encouraged infiltration. See Union of India's affidavit dated 5th December 2014 at paras 9 to 11 and para 14, volume 3, pages 1192 and 1195. Now, here your lordship will take 3 paras in particular, para 9, 11, and 14 of that affidavit. And 14 is very important because this entire alarm, I would like if your lordship could read para 14, page 1195, volume 3, page 1195. The entire alarm arose in 2004, a year before the Sarbananda Sonowal judgment came, because of an answer in Rajya Sabha. And that answer in Rajya Sabha said that 1.2 crore people from Bangladesh are in India, of whom 50 lakhs are in Assam. That was an estimate given. That was corrected in Rajya Sabha, saying that there was a field survey done, and the field survey itself said this is only hearsay by interested parties. But that footnote saying that this is that we have not been able to verify this is only based on hearsay by interested parties, was not placed before Rajya Sabha. So a correction was made before Rajya Sabha. Please just see that for a moment. Volume 3, page 1195 minutes. This has been virtually the foundation of all this. The previous paras gave the charts in the same, I showed your lordship 1192, etc. Now 1195, it is respectfully submitted that the petitioner, this is the Union of India, 5th December 2014, that the petitioner and the writ petitioner had mentioned about the response to the Rajya Sabha Unstarred Question 332 dated 14 July 2004, wherein it was informed that there were 1.2 crore illegal immigrants, illegal Bangladeshi nationals living in different parts of the country. Out of them, 50 lakhs were in Assam. In this connection, it is clarified that a statement correcting the answer to the Rajya Sabha Unstarred Question was placed in the House, stating that the estimated number of illegal immigrants reported by the field organization had a clarificatory note which was inadvertently not seen. The clarificatory note made it clear that the reported figures were not based on any comprehensive or sample study, but were based on hearsay, and that too from interested parties. Therefore, no realistic figures can be given for illegal Bangladeshi migrants in Assam. In the case of West Bengal also, the figures are based on unreliable estimates and are incorrect. A copy of the statement correcting the answer to the Rajya Sabha unstarred question dated so-and-so is the next year and marked as the next year R1. Now, if your lordship just moves 2 pages back to 1192, the actual figures, 1192 para 9,
Yes.
there's been a lot of alarmism, my lords, which is not rooted or grounded in reality. Now, see the actual figures at para 9, my lords, of the same affidavit.
Yes.
It is submitted. May I read that? Lords?
Yes.
It is submitted that as per records available, para 9 was at 1192. It is submitted that as per records available, about 52.31 lakh displaced persons from former East Pakistan had migrated to India between 1946 and 1971. These two paras, very short paras, at para 9 and 10, it is submitted that as per records available, about 52.31 lakh displaced persons from former East Pakistan had migrated to India between 1946 and 1971. Out of these, the displaced persons numbering 41.17 lakh who arrived up to 31st March 1958 were called old migrants, and those who arrived between 1164 and 25/3/71, numbering about 11.14 lakhs, were called new migrants. Out of the 41.17 lakhs old migrants, about 31.32 lakh were settled in West Bengal and 4.87 lakh persons in Assam. Out of the new migrants numbering 11.14 lakhs, 2.12 lakhs persons came to Assam. The remaining old and new migrants were rehabilitated in different states of the country under various schemes of the Government of India. Wide range of relief and rehabilitation measures were undertaken by the Government of India for rehabilitation of old and new migrants. The rehabilitation of old migrants was by and large completed by the end of 1960s and that of new migrants in 1980s. It is submitted that the state of Assam also witnessed migration from other provinces of undivided India even before partition of the country due to economic reasons. And your lordship will see this decadal variation between 1911 and 1951 or 1961. There's a huge amount, much higher than the national variation. The decadal growth in Assam, 1911, 1921, etc. Now, historically, this has been well recognized, and in my written submission, I've set this out, that even in the 19th century, leave alone the 20th century, there was a lot of Bengali settlements in Assam, and which led to a lot of disquiet because at one time Bengali was made the official language for about 12 years in the 19th century. The British had made it the official language of Assam. That had led to huge resentment. So every time Bengalis settled in Assam, this has nothing to do with Pakistan or India. This is way before independence. There was always resentment. There was always an upsurge of this fervor, and rightly so. So I'm only pointing out this has to be kept in mind.
Yes.
This alarmism has a historical background to it, which must be kept in mind because ultimately, human beings in large numbers get affected by an alarm against a race, not people from Pakistan, but a race of people who happen to be settled over there over the last 150, 200 years. Deeply obliged.
Thank you, Mr. Singh.
Only one.
Mr. Trivedi, you are for the AASU.
Well, para 9 may be seen with para 40.
Para
That's all.
14.
Of course, numbers, my lord, may not decide the validity, but
Let's see that.
Nine
Now,
will be
14
read.
also he read out 49.
What is the Rajya Sabha? Yes.
That Rajya Sabha clarification. That was based on hearsay, the
The
clarification.
learned solicitors, para 1 to 6 are very clear in your submission.
She is appearing for Ms. Malvika Trivedi.
My lord,
ASU in writ petition civil 562 of 2000.
My lord, respondent number 6 in writ petition 562 of 2012 and respondent number 5 in writ petition 876 of 2014. My one-pager written submissions are in volume 2C, pages 7 to 8, PDF 910.
Page number?
PDF page 910, my lord.
Volume 2C. No?
Pages 7, 8. My lord, just to give a brief background on All Assam Students Union, because a question had come from the Honorable Court that why Assam and why not West Bengal? The answer lies herein. It is because of this long agitation from 1979 to 1985, my lord.
To read that note, I will.
Please, my lord.
That's
That's
how you
the
focus.
first part of my note, and
Certainly.
also because
Let's read that. It's important,
Yes,
actually.
yes.
Let's read it.
So, my lords, the first point, the backdrop of the Assam Accord dated 15th August 1985. The Assam Accord was signed between the Union of India, State of Assam, All Assam Students Union and All Assam Jan Sangram Parishad in the backdrop of a 6-year-long movement, 1979 to 1985 in the state, against the unabated illegal migration of foreigners into Assam, their settlement in Assam and their inclusion in the voters list. During the agitation, about 860 persons who are considered as martyrs during the Assam movement lost their lives and thousands were injured due to police action. Very recently, the Martyrs' Day was actually in commemoration of these people who had lost their lives was held, my lords, in Assam. The state suffered tremendous political uncertainty with 4 changes of government and 3 spells of president's rule during the 6-year period. And this is very important, my lords, clause 13 and 14 of the Assam Accord, because this is on restoration of normalcy, which is the underlying concept under section 6A. That is the purpose it was brought into for the purposes of restoration of peace and normalcy in the state of Assam. And a book that sums it up, The Quest for Modern Assam by Arup Jyoti Saikia, which is also a part of the compilation. It has 2 chapters on each and every meeting that had gone on that time with the government and with the All Assam Students Union. The run-up till 1983, thereafter in 1985, after the Prime Minister's assassination, then in 1985, what were the events which led to the agreement behind this Assam Accord, and then it came into play. And the background that was discovered was also discussed and when finally agreed upon were the 1964 riots which had happened in East Pakistan, where there was mass massacre of the population and therefore they had escaped into India. So therefore they became a part of the 1967 electoral rolls. So therefore that part of the population that had come in at that stage was included, but the part after that, then the government agreed would be kept disenfranchised. Therefore, the period till 1971 where they were not included in the electoral rolls. So therefore, in the history of this entire accord is the agitation and therefore the difference between West Bengal and Assam for the purposes of this particular section. Now coming to my second point, where a lot of arguments were raised by the petitioners on the infiltration continuing. For that, I just want to point out one para from the reference order itself, para 46 is very important, because the point that we are making here is that the constitutional vires of a statutory provision cannot be tested on the basis of faulty or inadequate implementation of the said provision. And if my lords will only have para 46 of the reference order, it says, if I may just read the introduction, on an overall consideration of the immediate dimensions of the issues and the potential that the same have for the future, we issue the following directions under Article 142 of the Constitution of India. One is border fencing, border roads, and provision for floodlights. The second is foreigners' tribunals. The third is existing mechanism of deportation of declared illegal migrants. And in that, 48.1 preparatory work such as selection of vendor system, development by system integrator, appointment of staff and training, etc., has already been directed to be completed by the end of January 2015 by order dated 27/11/2014 of the court. 48.2, the remaining work of updating the NRC will now conform to the following time schedule, which will be strictly adhered to. And 49, all the cases, so on and so forth. So therefore, if my lords will see that this is the implementation that had to be carried out as per the Assam Accord, the absence of this implementation cannot be a reason to fault Section 6A. Then coming to the third point, which has already been addressed, so I will only talk about the case law very briefly to say that the petitioners are also disentitled from claiming the relief on account of inordinate delay. And for that, I only want to point out that whether it is Ram Chandra Shankar Deodhar, whether it is Rabindranath Bose, or whether it is Trilok Chand, the underlying concept in all these judgments is that if the rights of another set of people have already got created, then the delay in filing the petition cannot be then waived off. And my lords will just see, I have just given a few instances when they could have challenged and they did not. And therefore, these rights have now crystallized over 40 years. One instance that I've given, the report by the Lieutenant General S.K. Sinha was prepared on 8/11/98, which in detail talked about this problem.
Then comes that reply to the unstarred question,
Yes,
14
yes.
July 2012.
Absolutely. Absolutely.
And the petition Sarbanand Sonowal, you say, was filed in 2000.
Absolutely. And this actually considers the Assam Accord in para 18 and in para 33 in great detail. The next point, I will just on the legislative competence, I just want to point out one article just for the purposes of saying that how 5, 6, and 7, articles 5, 6, and 7, the purpose was that they would work themselves out at the commencement of the Constitution. I only want to point out Article 394. If I may read, this article and Articles 5, 6, 7, 8, 9, 60, 324, 366, 367 shall come into force at once, and the remaining provisions of this Constitution shall come into force on the 26th day of January 1950, which day is referred to in this Constitution as the commencement of this Constitution. So therefore, my lords, the 5, 6, 7 sections, the articles were supposed to come into effect on 26 November 1949, and therefore at the commencement of the Constitution, therefore by 26 January 1950, they were supposed to come into play for the grant of citizenship. And thereafter, therefore we have said that the purpose of Article 11 was only to add, not to deprive anybody, but to add a certain class of persons which were not covered by Articles 5 to 9. That is the point that I've covered in point 4. I've also given detailed submissions, my lords, which is there already on record. Another judgment that I wanted to add, because Izhar Ahmad, when it discusses in great detail Article 11, it is a Constitution bench judgment. It is very clear on what Article 11 entails, and it has been followed in state of UP versus Shah Mohammad. I have given the volume number and the pages. and also the para 5 of State of UP versus Shah Muhammad. It's a case very similar to Izhar Ahmad, and it follows Izhar Ahmad and again reiterates that Article 11 is supposed to then come into play for the purposes of the laws to be made for citizenship. My fifth point, very briefly, I have tried to state that Section 6A is not the only statutory provision to be based on a political agreement. And I have given two instances for this, Article 371A, which is the 13th Amendment Act, and it is based on the agreement between the Government of India and the leaders of the Naga People's Convention. Then I've also cited 6th Schedule, which is which is based on the Memorandum of Settlement entered into between the Government of India, Government of Assam, and Bodo Liberation Tigers. And this is now on the autonomous districts and autonomous regions. It covers the areas in the state of Assam, Meghalaya, Tripura, and Mizoram. Then I have just added some case law to say that the classification on the basis of historical or geographical reasons is absolutely valid. And therefore, I have only added the judgment in state of MP versus Bhopal Sugar was already cited before my lords. I have only added one more judgment on geographical classification, which is Ramkrishnan Dalmia versus Justice S.R. Tendolkar. And I have also added Clarence Pai versus Union of India. And in the end, I'm only making a point that if the history of this agitation is seen, it is actually wonderfully spelled out in the Quest for Modern Assam, which is also a part of volume 4A by Arup Jyoti Sakhya. It will be very clear that what had happened throughout this process and why, because of the Bihar settlers, why because of the Bengali language, and why this agitation became much more than what the people of Assam could handle, and therefore for peace and normalcy, the Section 6A was brought about.
Thank you so much. Thank you, Mr. Reddy.
Please, Your Lordship. I'll make a very quick fire 5 points. So your Lordships will not have to be.
You are in IA, what, 24 of 2017?
The IA that, my Lords, is 24 of 2017.
Assam State Jamiyat Ulema.
That's right, the State Jamiyat. My Lords, we've been deeply involved in all the CAA matters, etc., and we've been involved in the Assam Accord settlement right from the beginning. My Lords, we have I will not repeat anything that my learned colleagues have said.
Where is your note, Mr. One?
My Lords, your Lordship will file the note in volume 2C at pages 5 to 6. PDF page 7.
Yes.
And my Lords, the earlier note that I had given, what your Lordship will find in volume 2, there's the details are all given there. This is very, very brief because your Lordships want to just see.
Let's have a look at your note, Mr. Sashi.
So if your Lordship will see at PDF page 7, volume 2C, well, it's the first point, if your Lordship will focus on that. The first point essentially is to disclose that the migration issue is a global issue. And for Assam, it continued over centuries. So it wasn't as though something had suddenly happened, and the amalgam of different communities moving into migration, bringing different communities into Assam, gave what sociologists have said is a salad bowl. So there's two perceptions about a salad bowl and about a mosaic, or on the other hand, it would be a melting pot. So the preferred view seems to be of a salad bowl. This is how it existed, my Lords. But of course, as your Lordships have heard from the others, there were issues that were different as far as the western border was concerned and the eastern border. The issues on the eastern border was the constant move from one part of Bengal to another part of Bengal. So Assam was in a sense separate because they didn't want to impact on the issues between the two parts of Bengal. Assam then therefore becomes in a sense collateral to that issue. So Assam issue was never resolved in terms of the permit system that was introduced in the West. And the permit system, your lordships might recall, was particularly focused on the issue that people who had left and their homes had been given to refugees coming in from western part or from West Pakistan could not then be asked to evacuate their homes that they were given as refugees to return to people who had come back. And therefore, the permit system was particularly carefully monitored. This didn't happen in the eastern part, and particularly as your lordship saw Justice Baharul Islam's judgment, his speech in the Rajya Sabha, we've mentioned all that here, my lords, and therefore a separate issue had to be framed as far as the eastern side was concerned. And that, of course, the 64 was an obviously a landmark point, 64. 66 follows because 64 follows with the 67 electoral rolls. But the critical matter, my lords, is the 1971. 1971, if your lordship will see here in point number 2, if your lordship will see, Bangladesh had already introduced their citizenship law in 1972. We were introducing in 1985. So in effect, the 1971 aligns itself with the Bangladesh law. So there is no gap between Indian citizenship and Bangladesh citizenship. Your lordships were asking if it had something to do with Operation Searchlight and the migrations that would have been caused due to distress because of the Pakistani army operating. The Bangladesh government said they would take back all the people who had moved during that period. Because if they were in Bangladesh on the first day, which was on 25th of March, they would be citizens under the 72 law. And therefore, we were only concerned with people who were not in Bangladesh on the 25th of March. Those citizens would be taken care of, or those people would be taken care of by the Indian law. And it aligns. Now, my lords, if for any reason the 71 alignment is changed for any reason, it would mean that 40 years later, there are a huge number of stateless citizens, something to which we are not yet signed as far as the convention is concerned. But Government of India has always been careful about not creating or not being seen in the world as creating stateless citizens. And that is very critical point why your lordships would wish to uphold the 71 as the so-called cutoff date, though there is some issue about whether it should be called the cutoff date at all. So, my lords, that's point number 2 in my submissions. And my lords, point number 3 only follows upon what arguments have already been made, that it didn't freeze, the issue of citizenship didn't freeze in 1948 under the Citizenship Act of 1955. It continued with 6A, and then it continued subsequently in 2019 when further amendments were made for citizenship. Those may well be under challenge, but at least in theory, it was possible for the citizenship to continue in terms of fresh legislation. Then, my lords, the last 2 important points are, now there is a fresh affidavit that's been filed by Government of India. Those 2 points, the last 2 points, 4 and 5, indicate that the alarming picture that somehow emerged is not, my learned friends just before me had indicated this, but that alarming picture was misplaced. That the number of people so-called coming in was completely misplaced. Firstly, because the migration figures, as we now see from the affidavit, are much less compared to the ones that have been projected earlier. And then, my lords, in view of this affidavit, I would urge your lordships to consider whether the monitoring bench is the appropriate bench to continue with any issues that are indicated for future, and many of those issues are mentioned in the affidavit, rather than this honorable bench having to worry about what to do about the future prospects.
Thank you, Mr.
So, my lords, the only issue to recall is whether we are a salad bowl or we are a melting pot. Well, that's very critical in terms of sociology to understand. Your Lordships have already been told about how the cultural issue was protected by the schedules by which the culture and autonomy of the tribes of Assam was protected. And they are the ones who should really have been concerned, not the others. This is my submission. Deeply obliged, Lords.
Yes, Mr. Srinath.
I won't take more than 2 minutes, Miller.
Yes.
My application, Miller, IA 26869, Miller. That's on page number, at page number 1616 in volume 3.
A number 268.
26869. At page 1616 of volume 3. Page 1616 of page, volume 3. And my small short note, Miller, in volume 2C, page 9. Miller, all the points, Miller, raised by me, formulated by me, Miller, are adequately addressed now. So I don't want to waste the time, Miller, only to say one thing, that is, with a particular reference to argument submission made by Ms. Indira J.C. Senior Miller, that aspect regarding 29 Miller, that I fully adopt, Miller, because otherwise I would have argued that.
Thank you, Mr. Srinath. Mr. Farad, sir.
I am appearing. Your Lordships will have page 11 of the volume 2C. I'll only rely on the one page, Your Lords. Although I've submitted a detailed written submission. Page 11 of that is my submission. 3 short points for your Lordship's consideration.
Volume 2C, page?
Page 11 is a one page, Your Lords. I appear for, my Lords, in IA 10 in WPC 562 for Social Justice Forum, my Lords, which is an organization that works for a composite culture in Assam. Well, the first submission for your Lordship's consideration is that, well, the right to culture which they have asserted under Article 29, that in my respectful submission can never extend to denying somebody's citizenship. The reason for that is, well, the citizenship regime under Article 14, well, Article 14 is the only article your Lordships will normally test any citizenship regime under. That is a regime of civic nationalism, a non-discriminatory basis of grant of citizenship. The minute, my Lords, we elevate culture to the extent of denying somebody else citizenship, effectively, we have transgressed from the area of civic nationalism to cultural nationalism. Plus 29 certainly cannot extend to denying somebody else citizenship because the nature of citizenship regime itself under the Constitution then changes. Well, that's my first respectful submission. Your Lordships will have Article 29 just for a moment. The language there is, have a distinct language, script or culture of its own and shall have the right to conserve. Well, 29 is premised on a multicultural society. It is premised on multiple cultures and you have a right to conserve within that multicultural space your own culture. It is not a right for cultural exclusivity. Well, that's my respectful submission to your court. The way they have framed it, that I have a right to cultural exclusivity under 29 to deny other citizenship. The language, the plain text of 29, well, does not permit that. In fact, I would go so far as to say that if their arguments are accepted, Article 29 will in effect cease to exist. Because 29 is premised on a multicultural society. And in that respect, your Lordships will have Article 51A of the Constitution, subclause F. That talks about fundamental duties. Article 51 capital A subclause F is fundamental duties and it talks of composite culture. Every citizen's duty to maintain composite culture. Plus composite culture is a mix, is a bouquet of all the cultures within India. Therefore, my lords, when we read the Constitution as a whole, Article 29 can never extend to deny somebody else citizenship. Now, just one example in that respect. For instance, in Malaysia, we have Bumiputras. Literally it translates into son of the soil. Malaysia was very similar in facts to this situation. Due to British policy, Chinese and Indian migrants were moved into Malaysia. The indigenous Malays, as they were, had a problem, had angst against this movement. Now, citizenship is there for everybody across the board. Chinese Malaysians, Indian Malaysians or Malay Malaysians. But there is affirmative action which is provided because the Malays were socio-economically backward. So maybe there are aspects which, if they were to show that they are socio-economically backward, my submission is nothing on the data to indicate that, then those things can be taken care of. But you can't pitch it so high as to citizenship and then say nobody else will have citizenship. That's on point one. My second submission is that insofar as the reliance in Article 325 and 326 is concerned, plus 325 on its own terms, I'm not going to take your lordships to it, but on its own terms has the same markers of non-discrimination as in Article 15, race, religion, caste, etc. So 325 in fact goes against them because the citizenship regime has to be based without discrimination on basis of religion, etc. So many arguments, even on the grounds of change in demographics on religion was made. 325 prohibits that kind of discrimination, number one. Number two, under 326, the electorate is defined. It is by adult suffrage at intervals. It has to be brought, the electoral list is changed. Whereas that by itself envisages a continuously changing electorate. The composition of the electorate under 326 does not give a right to any specific group to have electoral dominance. Well, that's my submission for a lordship's consideration. 326 does not envisage that any specific group will continue to have electoral dominance. In fact, the terms of 326 are indicative that there is a flux in society, things can keep on changing, and therefore electoral roles must keep on changing. Well, that's the second submission. Well, my third and final submission for your lordship's consideration is that Assam Accord was, one aspect of the Assam Accord has been legalized in the form of 6A. There was another aspect, which was that a whole lot of violence occurred. And that was, amnesty was granted for that under the Assam Accord. For instance, in 83, there was a serious massacre called the Nelly massacre. Although, for serious crimes, the text of Assam Accord says that that is in effect excluded, but the way it operated on the ground, that all of that, in effect, was effectively, amnesty was provided. So today, after so many years, to pick on one aspect of 6A, whereas the petitioners represent groups which benefited from non-prosecution of multiple cases, in Nelly, there were deaths of 1,500 to 2,000 Bengali migrants. So all of that was shut out. So it's a compact to pick out one now, and you have benefited from other aspects of the compact. In my respectful submission, your lordships will look at that very closely. That's my respectful submission. I'm extremely grateful for the.
Thank you, Mr.
Lordship, my written submission in volume 2C at page number 9. In IA number 190221, I will take only 1 minute. Many foreigners illegally settled in the Assam and also other parts of country. It affects not only national security, but also democratic setup in the Assam and other states like Bengal also. Section 6A confers citizenship to large number of persons without being actually born within the territories of India. Section 6A seeks to provide protective discrimination to the class of illegal immigrants. Fourth point is, there may be some lacunae and drawbacks in the provision of the Section 6A of the Citizenship Act 1955 as read by the petitioner. But the
6A is unconstitutional. You are saying 6A is unconstitutional or constitutional?
Sir, it is constitutional. I am saying only that. And there may be some lacunae and the drawbacks in provision of the Section 6A of the Citizenship Act as raised by the petitioner, but the intention of the lawmakers is certainly fair. The provision of Section 6A are in favor of the integrity and national security of India, but there should be practical approach because immigrants may be illiterate and they cannot be at the ventilator for indefinite time. My humble submission.
Thank you, Mr.
My humble submission is that the provision of Section 6A of the Citizenship Act 1955 should be declared valid and the Constitution.
All yes. Now, who else? Who else?
But I'll just take exactly 2 minutes.
Yes, which?
And I appear for my lords Asama Pragya Jyotish, Priya Khiranjia, Musalman Union Parishad, APKM.
Some submission, 1-page submission.
Not 1 page, it's not.
Have you filed some submissions?
Yes, your lordships.
Oh, so what is the point? Who are you appearing for?
I'm appearing for in IA number, your lordships, in 562 41036 and of 217, and in WPC 274, my IA number is 153061 of 2022.
I will not bother your lordships with all the because everybody else has argued. I will.
Anything special now?
Yes.
What is that?
Otherwise, I will not bother. Let's to decide the questions before my lords in question number 4, 9, 10, and 11. There is a question of a friendly country, and your lordship has been kind enough to take the affidavit of the union. I am only submitting for your lordship's consideration that if your lordships can also ask the union to file an affidavit qua their interactions with this friendly nation on point number 4, 9, 10, and 11.
All right, we'll get
That's
to
one.
now. Yes.
2, my lords, 6A, absolutely technically, is a restrictive in nature provision, which restricts the rights or the provisions which are available in 6 before 1985. So it's not actually giving out something, it's restricting something for the provisions of section 6. 2004 amendments came later on. That's the second aspect. And third aspect, to confine myself to 3 minutes barrier, is that culture, point number 3, the abrogation of culture and dilution of culture, your lordships, will have to be considered on the parameter of the numbers. If more number of people, as it happened here, a lot of Bengali origin people adopted Assamese language, and therefore Assam language today is Assamese. So it is expansive in nature again. A lot of
That
Bengali
point is
origin.
made now. Thank you.
Thank you. Biplab.
But I appear in specially petition number 214.
What's the point?
But the point is, I will only confine to 2 aspects.
You're for the intervener.
No,
Sorry.
Malat, I am for the petitioner in Akhtara Khatun 501.3 and 501.6. Malat, I have uploaded my written submission just now. That's one pager only. And I confine myself only on 2-3 aspects. Malat, one is
What does the SLP arise from?
this is against the order of the High Court, whereby the individuals were declared as a non-citizen.
High Court declared
Yeah.
individuals as non-citizens.
And that is against that the SLP was filed. That was an individual case. But it has been tagged along, and this item number is 501.3 and 501.3.
Foreigners.
We
We will just detag. We will detag your case.
Only
No, we'll detag this
Got
case
it.
because we don't know what let the bench
that is
deal with this.
the
Why should we tag the Constitution?
the tribunal has declared us non-citizen. Then we went to High Court. Again, the High Court, we came to Supreme Court. And it has been tagged along with this batch of petition, my lord. I will make only 2 submissions. In 1 minute, I will finish.
There are 6 SLPs apparently. 1 second, just for clarity.
Yeah.
There are 6 SLPs. I don't think we should be going into the facts of SLPs over here. We'll just detag those matters.
I'm only on the broad.
You see, there's some injustice may be caused to your client because, we are hearing a question of law here.
Yes.
There's a constitutional challenge which we are considering.
Correct.
Individual facts of these 6 SLPs, after we deliver judgment, let it be placed before the regular bench.
This will affect the interest of my client. I will only make legal submission, not go into
Why?
the
But
fact.
you have not been protected under 6A also. You have been held to be a foreigner.
Yes.
So you will have to argue your SLP on facts.
That is true, my lord. The SLP has to be argued on fact. I am not arguing on fact, and I cannot argue before lordship because it is
All right.
confined only to
What is
6A.
it? Just in one
The
one
point is
sentence.
that, my lord, Article 5 to Article 9 deals with specific, there is time and situation is specific, my lord. And Parliament has given under 246 read with
That point has been
17.
made now. That point has been made now.
Yeah, so therefore, Article 10 and 11 both gives enough power, and
But that point has been
the
made by
Article
which
5 to 8, 5 to 9 were enacted
Thank you.
for the
Thank you.
purpose and
As-
keeping in
thank you.
view
SLPs को
of the movement.
detag कर दो, and after the bench, after that work, we'll place the Because we shouldn't get it because we'll have.
So Good.
Yes, Mr. Diwan.
Yeah.
Before Mr. Diwan commences, we had asked for an affidavit by the Union of India. Learned solicitor was there. Can we just quickly look at the affidavit? Because then that way you can deal with the affidavit in the.
Everything that has been stated.
Actually, the affidavit of. Of India dated 11 December 23.
विशाल मेहता सर
Data आ गया ना? So how many people have been granted citizenship? Says it is only submitted. Assuming that the workload.
May I read me so that?
Yes.
I'm sorry, Malad, I was called somewhere.
No, no.
Your Lordships are on page, Malad. I may not reread, Malad, that's the only reason.
Brothers, which page are we on generally? From which? Words perhaps we can see, I think.
Yes, Malad. My apologies, Malad, I was not here. Malad, your Lordship's queries, what this issue is concerned, Malad, was how many persons have been detected to be foreigners by an order of the Foreigners Tribunal under the Foreigners Tribunal Order 1964 with reference to the above period, that is 66 to 71. It is humbly submitted that the number is 32,381 till Lord, this date, Malad. There may be few cases, Malad, which may be pending, Malad, somewhere in the High Court or before this Honorable Court, but broadly, this number would not vary. The Para 6 is the second query of my lords. The estimated inflow of illegal migrants into India, including but not confined to the state of Assam. Lord, in substance, we have said that there is a porous border. They come clandestinely, and therefore it is not possible to give exact figure. It may not be an accurate figure, but the situation is a grim situation, my lord. I will not dispute the petitioners on that. Lord, Para 7, your lordship's query was in respect of persons who are alleged to have entered India, including state of Assam, after 25th of March. It is, my lord, what is, my lord, the Foreigners Tribunal's status? Well, there are 100 foreigners tribunals. The total number of cases disposed of are 334,966. The number of cases pending are 97,714. And Lord, against this tribunal's order, there is a writ remedy before the High Court. And my lord, 8,461 cases are pending. And my lord, the steps taken by the union government at the administrative level to deal with illegal immigration into territory of India, including the northeastern states, particularly the state of Assam. My lord, fencing part I'll come a little later, but other, my lord, in last 5 years, Ministry of Home Affairs, Government of India has released a total amount of rupees 122 crores as monetary allocation for the functioning of foreigners tribunals towards the expenditure incurred to be incurred by the state. Then B, monitoring of deportation of detected foreigners and convicted foreigners in the state of Assam is done by a standing committee headed by a joint secretary to the Government of India in the Ministry of External Affairs and having member from the state government of Assam. The standing committee has held 6 meetings so far in this regard. The state government or UT administration have been requested to take various actions with regard to illegal immigrants. Periodic meetings are convened at the level of Chief Secretary and DGPs to review the enforcement of legal provisions related to illegal migrants. Police authorities in the state or union territories and other law enforcement agencies may be constantly sensitized on the issue of illegal immigration of foreign nationals and be appraised of the legal provisions. Police authorities and other law enforcement agencies may be advised to keep a strict vigil and take appropriate, are advised, not maybe advised, are advised, prompt action to detect, identify and intercept illegal immigrants settled in state or UT concern. Adequate powers are vested with state governments or UT administration for detection, detention and deportation of illegally staying foreign nationals. Suitable penal action may are taken, there is a typo throughout, against illegally staying foreign nationals. After completion of legal proceedings, the movement of such illegal migrants may be restricted in detention or holding centers by issuing of appropriate orders under Section 3(2)(e) of the Foreigners Act, read with Para 11 of the Foreigners Order 1948. Action may also be taken against those who abet under Section 14(c) of the Foreigners Act. It's taken from the directive. Therefore, my lord, it is wrong expression. My lord, my apologies. Are directed, my lord, not me. Further, biographic and biometric particulars of such illegally staying foreign nationals are being taken. Immediate necessary action to cancel fraudulently obtained Indian identity document. It is further submitted that steps have been taken by Government of Assam to stop or prevent illegal immigration in Assam. It is submitted that various means and mechanisms are used to prevent and stop illegal immigration in Assam, as well as detection and deportation of illegal foreigners from Assam. Now, second line of defense. Assam Police border personnel, along with Assam Police armed branch personnel, are deployed in the second line of defense behind the border outposts of the Border Guarding Force, that is BSF, along the Anglo-Bangladesh border to keep vigil and to trace out infiltrators who might sneak past the BSF border outpost. The second line of defense is established as per decision taken in a tripartite talks held in March 99 in New Delhi. Presently, 14 number of border outposts and 14 numbers of patrol posts are functional as second line of defense unit in 4 districts of Assam, sharing international border with Bangladesh, to detect illegal migrants, carry out patrolling.
Just
and
1 second, sir.
Further, third unnumbered para, page 7. Further, additional 12 border outposts were approved at the second meeting of state level standing committee to monitor border security held on 24/12/2019 with a government memo dated 30th December 2019. These two second line of defense units play a crucial role in prevention of infiltration and detection of illegal foreigners. It is noteworthy to mention here that the second line of defense, that is border outpost or police patrol, is manned by both unarmed and armed branch personnel headed by mostly ex-servicemen, sub-inspectors who have adequate knowledge of border management, security due to their past military experience, and can easily coordinate and communicate with BSF to carry out the joint or individual patrolling. It is submitted that the border outpost or patrol post personnel are not engaged in any other duties. Then every district in Assam has a separate border branch under the command of the District Superintendent of Police border. Further, additional SP border, Deputy SP border are specifically posted in districts to look after the border works under command, control, guidance and supervision of Superintendent of Police. Further, in every police station, outpost, watch post, as well as foreigners tribunal, border personnel are posted for border works Furthermore, 500 task forces are also formed as per the order of the Honorable Supreme Court to apprehend the declared foreigners. Because even after declaration, they escape so that they may not be deported. Further, the Assam Police Border Organization takes necessary steps to detect and deport the illegal migrants from Assam as per law. Generally, based on information collected during village survey, source information, public complaint, and intensive revision of electoral rolls, etc., regular foreign tribunal or doubtful voter cases are initiated under Section 14 of the Foreigners Act against a suspected foreigner if he or she is not able to produce any valid document in support of his or her claim of being an Indian national. Thereafter, the cases are referred to the concerned Foreigners Tribunal for opinion. On receipt of Foreigner Tribunal's opinion, the declared foreigners are apprehended and detained in transit camp for onward deportation to their country of origin, that is Bangladesh. Then watch posts. Watch posts are established in infiltration-prone areas of Assam to conduct survey to detect infiltrators and subsequent legal action against them. Case initiation. Presently, 159 watch posts are functioning in 23 districts. Border protection grid. For effective border management involvement of various stakeholders, central and state agencies is inevitable. For this, the Ministry of Home Affairs of India, with a notification dated 2nd January 18, had directed establishment of border protection grid along the Indo-Bangladesh international border with the involvement of the state authorities and other stakeholders. Government of Assam has since finalized the SOP of border protection grid for Indo-Bangladesh international border of Assam. Main objective of the border protection grid are as follows: to present a foolproof mechanism with a view to make Assam free from illegal immigrants by detecting and deporting them to their country of origin, and to present such infiltration, to prevent such infiltrations in future. To prevent cross-border crimes into Indo-Bangladesh border, the functions and responsibilities of different stakeholders are clearly mentioned. Then lead intelligence agency meetings, that are frequently held. I may skip that. 9 is relevant, my lord. With reference to the query, the extent of border fencing which has been carried out, the steps which the union government intends to take to complete the exercise of border fencing, and estimated timelines to complete the exercise of border fencing. India shares 4,096.7 kilometers of international border with Bangladesh. It passes through the state of West Bengal, Meghalaya, Mizoram, Tripura, and Assam. The border is porous, crisscrossed by rivers, hilly and mountainous terrains. Out of 4,096.7 kilometer Indo-Bangladesh border length, feasible length for fence is about 3,922 kilometers, and non-feasible length is about 174.5 kilometers. When there is a mountainous terrain or river, there is no fencing possible. To secure the Indo-Bangladesh border, Government of India has taken multi-pronged step to complete the remaining length either by fence or by technological solutions. For the entire Indo-Bangladesh border, about 81.5% fence work has been completed in feasible length, and work is going on in those feasible stretches where encumbrance-free site is available. Further, about 28.2% of non-feasible gaps, that is riverline, nala gaps, etc., in Assam and Tripura have been covered by deploying technological solutions. In remaining parts, in West Bengal, Meghalaya, and Mizoram, suitable technological solutions are being explored in consultation with Defense Research Development Organization and Central Public Works Department. In addition to above, keeping in view the vulnerability of the border, BSF had carried out a vulnerable mapping exercise to identify the vulnerable stretches, non-feasible stretches, or stretches along existing fence along the Indo-Bangladesh border. To cover these vulnerable stretches, Government of India has sanctioned a low-cost technological solutions covering a total length of 281 kilometers along Indo-Bangladesh border, which is in progress and likely to be completed by September 2024. Further, the Government of India reviews the progress of fencing work regularly through institutionalized mechanisms like Empowered Committee on Border Infrastructure, being headed by the Cabinet Secretary, high-level empowered committee being headed by the Union Home Secretary, steering committee being headed by the Secretary Border Management, state-level standing committee being headed by the Chief Secretary of concerned states. Apart from this, to expedite the border fence work, it is being reviewed in Ministry at Joint Secretary, Border Management 1 level and Director level monthly and weekly respectively. All efforts are being made to secure the remaining length of Indo-Bangladesh border either by fence or by technological solutions. The fence work is likely to be completed in 3 years' time after availability of encumbrance-free site. The site is to be provided by the state, that's the problem. And the technological solutions are expected to be put in place in 2 years' time. Specifically, state of Assam shares approximately 263 kilometers of international border with Bangladesh, out of which 210 kilometers has been covered by fence and remaining non-feasible length has been covered by technological solutions. It is specifically submitted that challenges have also been faced in the state of West Bengal with regard to illegal immigration. It is submitted that the state of West Bengal shares about 2,216 kilometers border with Bangladesh. Out of 2216.7 kilometers of international border with Bangladesh, 78% border of feasible length is covered with fence. The details of remaining length of feasible or non-feasible stretches in the state of West Bengal is as under. My lord, I have given the figures, my lord. And A, the status of feasible length in West Bengal, it is submitted that a feasible length of 435 kilometers remains to be covered by the fence. It is submitted that out of the same, 286.35 kilometers is pending due to land acquisition
by the state. Further, it may be noted that about 149.154 kilometer stretch, including bridges, culverts, gaps, low-lying public protest, etc., which was earlier considered to be non-feasible, has now been considered to be feasible for installation of physical barriers, including fencing, sentry posts, high mast light, etc., as per BSF and CPWD recommendation. Estimates are being prepared to cover this stretch also. It is submitted that despite all efforts, the progress has been substantially hindered due to the pending land acquisition issues with the government of West Bengal. The state government has not adopted right to fair compensation and transparency in Land Acquisition and Rehabilitation Act 2013. As per this act, in cases of urgency, the appropriate government can take possession of any land needed for public purpose, and such land shall thereupon vest absolutely in the government, free from all encumbrances. It is submitted that West Bengal government follows a far slower, more complex, direct land purchase policy. This is, my lord, the main hindrance, even for national security projects such as border fencing. Due to the non-cooperation from the state government regarding resolving various issues of land acquisition, considerable delays have occurred in acquiring the necessary land, thereby impeding the timely completion of fencing in West Bengal along Indo-Bangladesh border, which is a vital national security project. My lord, I have avoided giving any correspondence, discussions, details, etc. with a view, my lord, not to make it other than, my lord, just fact specific. But this is the problem we are facing, and the central government, my lord, can do little in land acquisition. Then status of non-feasible land in West Bengal.
Mr. Solicitor, who pays the compensation, union or the state?
The state.
But, my lord, if this is not the cause for which urgency clause is to be invoked, I don't think there can be any other cause. Integrity of the state, security of the country. Direct land purchase policy usually is adopted in case when you are acquiring land for some industrial purpose or industrial township, etc., not for national security concerns.
Issue is of compensation mainly.
Correct. But, my lord, that has to be priority, my lord, even if
No, I'm sorry, my lord, I'm sorry, my stand corrected. For border fencing, we pay the compensation.
Right.
Only, my lord, they are the agency which can do it under the Land Acquisition Act.
But they follow the direct purchase policy.
Direct purchase policy, my lord, which for border, they may follow, my lord, we have no difficulty, but for border fencing, they cannot follow. Then urgency clause will have to be invoked.
And my lord, I'm sorry, I stand corrected. The Union of India pays the compensation. Then status of non-feasible length in West Bengal. It is submitted that the length of non-feasible stretch to be completed is 112.780 kilometers, which falls in Sundarbans areas and is being planned to be covered by deploying technological solutions. A joint physical inspection has been carried out by BSF and CPWD to explore the feasibility for construction of 9 number of outpost towers in Sundarban areas which can house surveillance equipments. It is further submitted that the ministry has also sanctioned 301.2.5 kilometer replacement upgradation of new design fence in West Bengal. Out of this, 56.21 kilometers new design fence work is in progress, and for remaining length, tendering is in process. It is submitted that to secure the Indo-Bangladesh border in West Bengal, Government of India has taken multi-pronged steps to complete the remaining length either by fence or by technological solutions. If the state of West Bengal cooperates in acquiring the land and handing over the land for fencing, the central government shall complete the process without any delay. Lord, this is, Lord, in respectful response to the order passed by your lordships, Lord, on the earlier occasion. Lord, before the petitioner starts, Lord, only one thing. I don't think, Lord, that may have any relevance for the purpose of deciding validity of Section 6A. But some history referred to by my learned senior friend, Lord, it seems he has read a wrong book of history. Assam was never a part of Myanmar. Lord, that, because this has some relevance when we deal with some other matter at some other level, in some other, my lord, composition. It was never a part, my lord, because Myanmar has now, my lord, maximum immigration. And therefore, to say that it was always a part of Assam,
India of today what is Assam, and then the British took it over. That's what I said, and I referred to the chapter in the history in the book, which says
that's
not my statement. I mean, this is completely, quite frankly, the website of the Assam government also says the same thing.
Anyway, I don't wish to join issue on that, my lord. But this was a wrong book my learned friend read. That's all I kindly look at your own website. It says exactly that. Your own website. So let's not get it. Anyway, yes. Anyway, I leave it at that. I don't want to embarrass Mr. Sibal.
Just give me half a second.
Just half a second. Yes, Mr. Only with permission of the Lord. The issue of my lord influx from Myanmar is separately, my lord, pending before your lordships. And there are other issues also pending, my lord. Therefore, I repeatedly, my lord. They also said the same thing that yes, my lord, this is confined to the validity of 6A. Confine ourselves to 6A, the validity of 6A, because context of not being able to map the movement of population. That's all that I was saying. All right. Yes, Mr. Dewan.
Since you
yes,
referred to the question of delay and lashes, I should have given your lordships a citation. Just because the principle is like this.
Yes.
If a wrongful act causes an injury which is complete, a damage arising out of the wrongful act, even continuous, will not be a continuous wrong. That is in 1959 Supplement to SCR 476. 1959 Supplement to SCR 476.
Paragraph 39 of the judgment. What they say is there is a distinction between a continuing wrong and a wrong or a default, which is complete when it is committed. So 1971 Assam Accord. So complete when it is committed. This judgment has been quoted with approval in the Ram Janmabhoomi case. That is 2021 SEC 1, which is the Constitution bench.
2020?
2021 SEC 1. That's right.
Yes. Namulas, may I just request you to take up the Citizenship Act, please? And with your permission, I will only make points and points in rejoinder. So I'll go point-wise.
Yes.
Now, the first set of points is on what I understand there's common ground, because we've now heard what the respondents have to say. So I think the first is quite obvious, that we are only concerned with Assam. There's a geographic limit. We are all agreed on that.
The second point, as I took in the respondent's reply, it appears that it's now common ground that there's no temporal limit to the operation of Section 6A. The Solicitor General once mentioned transitory provision. I'll come to that separately. But 6A applies even to this day. It's not as if 6A applies and there is a cut-off date or a cut-off point of time. I think that's very, very important. You can make an application even today for the purposes of gaining a benefit under Section 6A. And I think that's very important, and it's common ground now that there is no, therefore, temporal limit to the operation of 6A. The third point which I wish to make, on which again there is commonality, is both sides are agreed that for the benefit of 6A, the notion of ordinarily resident in Assam is crucial and vital. There's no running away from that. Ordinarily resident in Assam is an embedded notion as far as the statute is concerned, whether you're under 2, you're under 3, that's an important feature. And the final point which I want to make, on which I think there is now commonality, is with regard to the essential ingredients for the operation of 6A. Number 1, the person must be of Indian origin as defined.
Number 2, she must come into Assam. Number 3, she must come from Bangladesh. Number 4, what I mentioned a while ago, must be ordinarily resident in Assam. These are the 4. So we are now all agreed on with regard to those essential requirements. Now please take up the Citizenship Act. Go directly to Section 6A. Now I'll just make my points. I'm focusing initially on 6A2. Please take up 6A2. First point, it's now common ground that there is no machinery for the purposes of evaluating, assessing, and determining grant of citizenship under 6A2. No machinery. Now, notice, legislature prescribes 4 criteria. Please take up 6A2. It prescribes the 4 criteria I indicated. It then provides no machinery for determining any of the 4 criteria, which is the person from Indian origin? Has the person entered Assam before 1166? Has the person entered from Bangladesh? And is he resident, ordinarily resident in Assam. There are 4 specific criteria. But these 4 specific criteria are factual. To qualify under 6A2, you must meet these conditions. You must meet that's what the legislature says. But there's no machinery to determine these conditions. So what is the net effect of that? The net effect of that is, I believe this is a fatal flaw in the scheme. As far as 6A2, I'm only on 6A2 now. By providing, if you had, just take a situation, if you had not provided any criteria, then my submission would have been, this is completely void because you cannot distribute citizenship without rational, reasonable criteria. That's the foundation as far as the constitutional logic and the constitutional and good governance is concerned. There must be some criteria. To which the answer would be, but we have criteria. We have 4 criteria. But when you prescribe 4 criteria facially and do not couple that with a machinery to evaluate and assess those criteria, you are in short prescribing no criteria at all. And this is now fatal, according to us, as far as 6.2 is concerned. It just can't stand. You can't prescribe criteria, then have no machinery, and therefore just start granting citizenship. So now what's the net effect of this? The net effect of this is that any person, because it's 57 years now, since 1st January 66. So anyone over the age of 57 in Assam can claim citizenship without the requirement of establishing ancestry or provenance. That's the net effect. You are just, your carte blanche, just granting citizenship because you have no machinery. So basically what is happening is, this is the grant of citizenship without scrutiny. It is a criteria-less citizenship. 6.2, I'm only on 6.2. In effect, it is a criteria-less citizenship. And this, I don't believe Parliament can do, even though it has the legislative competence. No action under our constitution can be so completely devoid of any rationality or any basis. You prescribe it. All right, good luck. You prescribe it. But then what's your machinery to determine these 4 points? That the person has entered Assam, come from Bangladesh, is of Indian origin, which is defined, and is ordinarily resident in Assam. Nothing at all for 1st January 66. So I would respectfully therefore submit that insofar as 6.2 is concerned, it ought to go. That's all. I can't say anything further. It ought to go. You can't have a system of criteria-less citizenship. Facially, oh, we've got 4 conditions, but there's no machinery. That's the end of it. So this is now my first set of points. My focus was on 6.2. Now I move to 6A3. Sorry.
What will happen then is this, that suppose somebody is detected to be a foreigner.
I'll come to that. Yes,
suppose
yes,
he is detected or she is detected to be a prima facie a case of a foreigner.
Yeah.
Notice is issued to that person.
Yeah.
That person says that, look, I am protected by the deeming conferment of citizenship by 6A2. The onus is on that person then to establish that these 4 conditions were satisfied by them.
So
so they have to then establish that, look, we must also understand that we are dealing with people who came in before 1966. That's why Parliament made this classification.
That's right.
But if notice is given to a person that, look, you are claiming to be under 6A2, but you have never come before 66. You are feigning something which you are not.
Yeah.
That person must show first entry before 66 or entry by an ancestor, parent, grandparent.
Yes.
To entry from Assam, 3 ordinary.
So let me answer that. Let me answer that. Now I'm back. I'd moved to 6A3, but now I'm going back to 6A2.
This deeming conferment of citizenship is on those people who genuinely meet that description in 6A2.
True.
It does not confer citizenship on anybody who is just in India before 66.
But now, so let me answer that. Now let's focus on this and your lordship's point with regard. May I continue after?
Yeah, continue.
What?
start because this will go.
परमिशन तो मांगता हूँ।
Yes, sir, Ashok sir.
Yeah, I just want
Mr. Diwan, I was actually reflecting on what you said at lunch.
Yes.
See, look at it this way, when the law provides for, I may be wrong, I'm just formulating it.
Yeah, but let's see 682, yes.
Now, when the law provides for a deeming consequence,
Yes, correct, correct.
that consequence operates without any adjudication or without application of mind to the facts of a particular case.
Generally, but not here,
That
maybe.
Law, the deeming consequence, what we call a deeming fiction for
I would accept that.
right? Now, when the consequence is called into question in an individual case,
Yeah.
on the ground that the conditions requisite for attaining that consequence are absent, your four conditions. The fact that, those four conditions were not satisfied or any of them was not satisfied, and therefore the person is not entitled to the benefit of the deeming consequence, is always up for adjudication.
That's
So
not the
suppose, for
scheme.
instance, somebody, I'll tell you, somebody now, a person prior to 66
Yeah,
applies for an Indian passport,
yeah.
all right? Or their child, now there'll be those people who will be now, as you
57
said,
plus.
57 years old. Already that person applies for a passport.
I mean, at least 50.
The passport officer says that, look, I can't give you a passport. You're not an Indian citizen. Then at that stage, if he says, no, I'm an Indian citizen by virtue of 682, I'm not saying the passport officer will do that adjudication. He has no power to do that adjudication. But certainly, the validity of his status can be then decided. Suppose somebody applies for some other social welfare benefit which is available only for a citizen. Otherwise, we can clarify that actually, that this is not, that anybody who claims that status gets the status.
So let me just answer this. Now, your Lordship has formulated. So I have 2-3 answers to it straight away. So just look at 682, please.
Yes.
Just have a look at 682. I'll just read some parts of it. You see, subject to the provisions of 6 and 7, all persons of Indian origin who came before 1st January 1966 to Assam from the specified territory, including those, etc., who were included in the electoral roll for 67, and who have been ordinarily resident in Assam since the dates of their entry into Assam, shall be deemed to be citizens of India as and from first day of January 1966. And as your Lordships have seen, this provision comes onto the statute book with effect from 7th of December 1985. So it has, the deeming is not just deeming with regard to who becomes a citizen, but also from when the person becomes a citizen. That's very important. Deemed to be a citizen as from 1st January 66. Now we're not going, there's some rationale provided, etc., because there were elections held, etc. We're not getting into any of that. I am first examining this subsection facially. So assume everything is, what it says, what it means to say. So 4 conditions your Lordships have specified, I don't want to repeat it. Now look at the manner and the mechanics of it. First question, are there criteria? I'm just asking myself.
Criteria there are.
I believe there are criteria. So you cannot assail a provision on the ground that this is just being handed out to anybody and everybody without criteria. And criteria is necessary, I believe, for the grant of citizenship. There must be some rational application of mind, some objective criteria. Now, there are objective criteria. That's the other part. It's not just criteria, they are objective criteria.
Right.
Now, those objective criteria are on the basis of certain fact situations. Now, I'll take a simple one. You have to enter into Assam. Not, that's my other point, but let's keep that aside. Not West Bengal, not enter. It has to be to Assam. That's one point. It has to be prior to 1/1/66. It has to be from Bangladesh. and you have to be thereafter resident. Now, all these elements, I'm just suggesting to the court, because what is deeming? Deeming, according to us, is a basket of rights. Just a
there
minute.
has to be a machinery.
Yeah, no, so I'll come to that. It's a basket of rights. Citizenship is a basket of rights. And that basket of rights includes political rights, it includes civil rights, it may include social rights, it may include economic rights. This is a very important concept because that will also tie into your some tentative observations were made of does proportionality have any role in this, and we'll try and suggest some solution.
Mr. Chief is saying is this.
Yeah.
You are right. Now it is ultimately for the individual to have his own view of satisfaction of these four criteria.
Yeah.
Now
there's also the
merely because subsection 2 does not speak about it.
Yeah.
The question is, will that take away the power of the state government,
right,
to go into that issue and satisfy itself whether A or B satisfy this?
So may I answer that?
Yes.
I'll answer that straight away.
Okay.
My respectful submission is that and there'll be some guidance from some case law, which I'll place presently. But once you specify criteria, you must, in the facts and circumstances of this case and having regard to the nature of this provision, have a machinery to determine those
But
criteria.
see, a deeming fiction is provided by the Constitution itself in Article 7. The Constitution itself provides for a deeming grant of citizenship in Article 6.
Yes.
There is no machinery in Article 6. Of course, you can't challenge an original provision of the Constitution that it is violated. See, Article 6 also says,
right,
so, notwithstanding, etc.,
yeah,
shall be deemed to be a citizen of India at the commencement of the Constitution.
I accept that.
So, even the Constitution.
But that is the
didn't
starting
provide for
provision, my lord. Someone had to be a citizen of India, so there was a cut-off date which was prescribed, and there were provisions which were made. That's very different, according to us.
But if somebody were to claim the benefit of Article 6 citizenship,
yeah,
then the question as to whether he or she satisfies
should there be a
your
contest?
B,
Right.
that can be gone into.
So may I answer that in this manner? I accept the provision. I accept the position that you may have certain circumstances, such as at the inception of the Constitution or at the starting of the Constitution, when you may not require to have a case-by-case determination insofar as individuals are concerned. However, the nature of 6A2, and I'm not putting it any higher than that, 6A2, by prescribing objective criteria, required, according to us, a machinery to ascertain those objective criteria in individual cases. It can't be just as a defense mechanism when someone wants to take action against you that it happens. Because you're conferring a basket of rights, including political rights and the full range of rights. So that, my lords, is my respectful submission. And according to me, our submission is that this is fatal as far as this. Because otherwise it really amounts to saying, now I'll just flip it around. Supposing they provided no criteria. Ultimately, that's what it means. If you are not providing a machinery, it is a criteria-less citizenship with a date of 1st January 66, because nobody is required to go through any evaluation process at all. That's exactly as the Chief Justice correctly observed, that probably happened at the inception of the Constitution, where there was a presumption that everybody who was there on or before a particular date is deemed to be the citizen of India. So that's okay there, but is it now okay here is the question for your lordships to consider. Yeah. Right. Yeah. That, my lords, that permit system, etc., has been explained to your lordships. So these, my lords, are my submissions as far as 6.2 is concerned. Now I want to go to 6A3. I'm sorry.
6A3.
Yeah. Now on 6A3 again, first point, no time limit. I think that's common ground. Now, if no time limit is provided for working out this section, according to us, the section itself is vulnerable, and I have premised this submission on the basis that we suggested a few expressions that the provision remains on the statute book and continues to act as a beacon indefinitely. It's like a magnet which attracts people to Assam with all the consequences as far as illegal migrants are concerned. And therefore, in our respectful submission, this itself, this is a fatal element to it, namely that there is no time limit which is prescribed within which this process is to be completed. It can be done tomorrow as well. That's open-ended, and that's very, very dangerous and wrong and illegal according to us. So this is our next respectful submission. Now, Milord, I'm focusing on another concept. And the concept which I'm now focusing on is person ordinarily resident in Assam.
This is under the 6A3 challenge, right?
Yes, but it's actually, it will span both, correct? Because that same expression is used here. But I'll just make the point. I'll just make the point. Now, if we go to 6A1, you will find, if you just have a look at 6A1, you will find there's a definition as far as Assam is concerned, detected to be a foreigner, specified territory, deemed to be a person deemed to be of Indian origin, and deemed to have been detected. Your Lordship sees that? The expressions which are defined. Person ordinarily resident in Assam is not defined. Now, this is very, very important for my purposes, because this is really the entire fulcrum on which both the sections and the subsections and the entire scheme operates. And this was my primary grievance, if Your Lordship recalls in the opening. This whole business of making it persons ordinarily resident in India and compelling everyone to remain there. Well, that's one aspect. But now let's focus on 6A3. Now, I ask myself, if you have certain statutes like, say, FEMA, Income Tax Act, you have notions of residency defined or linked to the number of days. Maybe 182 days, it may be something more, but you have to have a clear definition. It cannot suffer from this type of vagueness, undefined expression. Key core provision of resident in India, ordinarily resident in India, person ordinarily resident in Assam, I'm sorry. What does that mean? Is it 1 week? Is it 5 weeks? Is it 6 months? Is it 5 years? Is it 2 years? No yardstick at all provided. And this, according to us, cuts across both subsections. It leaves it completely vague. And in our respectful submission, if we are right, unconstitutionally vague. See, the vice of extreme vagueness in a situation for a core concept such as this, what does it leave it? What is the guidance given to a foreigners tribunal or anyone else? What is ordinary? This is a question I ask myself. Now, in this regard, actually in both respects, machinery, absence of machinery, as well as for vagueness, we have some guidance to be obtained from a decision of Your Lordships. Which is it? Yes, this, my lords, I'll just give you the citation very quickly. This is a judgment, yes, of a constitution bench. I'll give you the citation. 69-2 SCC 166. Yeah. Harakchand Ratnachand Banthia versus Union of India. I'll just request the court master to put it up. 69-2 SCC 166. This had to do, and the relevant paragraph I should just indicate is para 21, in the context of renewal of licenses. At page 1, I think it may be at page 1, para 21. It begins with, we now come to section 20. Yes. So I'll just place this, it spans both issues. And it's self-explanatory when I read the para. We now come to section 27 of the Act, which relates to licensing of dealers. It was stated on behalf of the petitioners that the conditions imposed by subsection 6 of section 27 for the grant or renewal of licenses are uncertain, vague, and unintelligible, and consequently wide and unfettered power was conferred upon the statutory authorities in the matter of grant of renewal of license. In our opinion, the contention is well-founded and must be accepted as correct. Section 27(6)(a) states that in the matter of issue of renewal of license, the administrator shall have regard to the number of dealers existing in the region in which the applicant intends to carry on business as a dealer. But the word region is nowhere defined in the Act. Similarly, sections 27(6)(b) requires the administrator to have regard to the anticipated demand as estimated by him for ornaments in that region. The expression anticipated demand is a vague expression which is not capable of objective assessment and is bound to lead to a great deal of uncertainty. Similarly, the expression suitability of the applicant in 27.6e and public interest in 27.6g do not provide any objective standard or norm of guidance. For these reasons, it must be held that clauses so-and-so impose unreasonable restrictions on the fundamental right of the petitioners to carry on their trade and are constitutionally invalid. It was also contended that there was no reason why the condition for renewal of license should be rigorous as the condition for initial grant of license. The requirement of strict condition for the renewal of license renders the entire future of the business of dealers uncertain and subjects it to caprice and arbitrary will of the administrative authorities. There is justification for this argument, and the requirement of Section 26 of the Act imposing the same conditions for the renewal of license as for the initial grant appears to be unreasonable. In our opinion, so-and-so are inextricably bound up with the other clauses in Section 27.6 and form part of a single scheme. The result is that clauses so-and-so are not severable, and the entire Section 27.6 must be held invalid. 27.2d of the Act states that the valid license issued by the administrator may contain such conditions, limitations, and restrictions as the administrator may think fit to impose, and different conditions, limitations, or restrictions may be imposed on different classes of dealers. On the face of it, this subsection confers such wide and vague power upon the administrator that it is difficult to limit its scope. In our opinion, 27.2d of the Act must be struck down as unreasonable restriction on the fundamental right of the petitioners to carry on business. It appears, however, to us that if Section 27.2d and 27.6, etc. are invalid, the licensing scheme contemplated in the rest of 27 cannot be worked. It is therefore necessary for Parliament to enact fresh legislation, etc. So this is important in the context of vagueness, which your Lordship... Are we going there directly? Yeah. Yes. So this, my lords, I think, at least we feel that this is persuasive on the point that when you have such key concepts which remain completely undefined and open-ended, we are left guessing as to what is the exact contour or parameter of persons, my lords, who are resident, shall be ordinarily resident in India, in Assam, I'm sorry, since the dates of entry, etc. So this is too crucial a concept without any parameter, anything laid out. So anyway, I'm done now with this point. Yes. Now this I should, yes, your Lordship may just note it, that this was followed to strike down 66A in, I'll give you the citation, Shreya Singhal versus Union of India. That's of course a two-judge bench, my lords. 2015, volume 5 SCC, page 1, at paragraphs 55 to 68 and 85, two learned judges. And in Shaira Bano versus Union of India, this aspect is now regarded as a facet of manifest arbitrariness. In Justice Nariman's judgment, 2017, 9 SCC, page 1, paragraph 101. That is, my lords, at index number 163 of volume 5 before your lordship. Shaira Bano is there. So now this is one aspect. Now there's one other one other aspect which I'll just, since we are on this machinery aspect, I'll just indicate. We have the advantage of a constitution bench judgment in state of Madhya Pradesh versus Baldeo Prasad. The citation is 61, 1 SCR 970. And from the SCC print, it is paragraphs 8 and 9 that are relevant. Oh. Okay, we'll try and get that. It's the paragraph beginning, the section does not provide that. Further down. Here. Incidentally. Above this? Yes, just above. Yes, yes, here. Here. The section does not, your lordship has that. Now, I'll just explain this. This was in the context of the Gunda Act. And the provision was struck down by the High Court, upheld by the Supreme Court, because the definitions were just so completely vague. Now, just 2 paragraphs. The section does not provide that the district magistrate must first come to a decision that the person against whom he proposes to take action is a Gunda and gives him no guidance or assistance in the said matter. It is true that under Section 4, a Gunda is entitled to have an opportunity to be heard after he is given a copy of the grounds on which the order is proposed to be made against him. But there is no doubt at all, that all the Gunda is entitled to show in response to the notice is to challenge the correctness of the grounds alleged against him. The inquiry does not contemplate an investigation into the question as to whether a person is a Gunda or not. The position, therefore, is that the district magistrate can proceed against a person without being required to come to a formal decision as to whether the said person is a Gunda or not, and in any event, no opportunity is intended to be given to the person to show cause he is not a Gunda. The failure of the section to make a provision in that behalf undoubtedly constitutes a serious infirmity in the scheme. So what we are is trying to draw sustenance in terms of our argument is that providing a machinery for determining and not just issuing a show cause notice to Gunda, you can't, this converse point, namely that, oh, it might be weeded out in a process if and when someone is detected, is not enough. There ought to be, in our respectful submission, I'm sorry.
Those who take the benefit of subsection 3, there is a machinery.
For 3, there is a machinery.
There is a machinery by the explanation. So when
Yes.
you apply
No,
for
there's no doubt
registration-
about that.
Yeah.
There's no doubt about
There's
it.
no machinery for
No, you're right,
subsection
absolutely.
2.
This is, my machinery argument is confined only insofar as
subsection 2.
2 is concerned, and also to the extent that if you haven't defined a person who is ordinarily resident in Assam, I mean, then what is the inquiry going to be? I mean, it's just completely vague. What machinery can the machinery do also? This is such a crucial concept, my lord. It has to be in some days, numbers, something has to be there. Ordinary resident, it's just otherwise completely.
You have artificial definitions for fiscal legislation, like income tax.
Right.
180 days.
Yes, right.
For FEMA,
Right.
whatever, 270 days.
Yeah, yeah.
But these are not, in that sense, fiscal enactments. For the fiscal enactments, it normally will have a very precise definition.
Yeah.
You're conferring citizenship.
Yeah.
So ordinary resident is not, it's not a term of art. It has the ordinary connotation. Somebody who...
But how many days? I ask myself.
It won't be, say, ordinary residence for 2 days or ordinary residence for 3 days.
But what is it, 6 months?
You're right. There is no precise definition.
Frankly, Malad, the law is actually to the contrary. If you with an intention move, so for example, someone like me sort of moved cities and came to Delhi. If a person moves to Delhi and even on day 5, if I've intended to move to Delhi, I would then probably have to describe myself as resident if I pack my bags, etc. at day 2.
Intention to reside.
Yes, but here, therefore, you have a situation, Malad, please, this is in the context of illegal migrants, Malad. It's not an ordinary person translocating within the country, etc. And so, having regard to that factual matrix, absent any criteria, any guidance, I believe it is constitutionally infirm in terms of an absence of any definition. So, Manoj, I am now done with this particular aspect as well. Now, I go to my next point. Now, here I wish to draw support from the joint communique. So, I'll just state the point. First, the point is this. The point is neither the... Sorry, one more point, Manoj, in that notion of ordinarily resident in Assam. I'll just make that point and then I'll move to the next one. This is not a concept which we found embedded anywhere, either in the Assam Accord or indeed in the communique. I'll just state that point. So that has no basis at all. That's a creation and a construct. There's no historical basis. There is no commitment in terms of international obligations or anything like that as far as this notion of ordinarily resident in Assam is concerned. Now, Manoj, I'm on the communique. Now, would your lordship please, sorry. Yes, your lordships will find that at serial number 4A, page 9398. And it's at serial number 94.
Volume?
4A. So I'll just state my points quickly on this communique.
4A, page 94.
Yeah. No, the page is 9398. Page 9398 of volume 4A.
Yeah.
So I have 2 points here. Lordships have the communique.
Yes.
So if you have page 9398, to just see the second paragraph of the communique, starting with the words during his stay. During his stay, the Prime Minister of Bangladesh addressed a mammoth gathering of people of Calcutta. He expressed gratitude on behalf of the government and people of Bangladesh to the government and people of India, especially to the neighboring states of West Bengal, Tripura, Meghalaya, and Assam for the hospitality and assistance given to the millions of Bangladesh citizens and for the moral and material support given by the government and the people of India to the struggle for liberation. And then your lordships will see a further reference to that date, 25th March 1971. That's towards the foot. The Prime Minister of Bangladesh solemnly reaffirmed his resolve to ensure by every means the return of all the refugees who have taken shelter in India since 25th March 1971 and to strive, etc., etc. So I make 2 points. The first point I wish to make is, this is not specific to Assam. Well, let's be very clear on that. This communique doesn't single out Assam at all. And I make a second point, which is, in fact, the communique treats the neighboring states of West Bengal, Tripura, Meghalaya, and Assam as a single set of bordering states for which the Prime Minister of Bangladesh also accords his great thanks and extends his thanks to the people of these states. So I believe this supports our submissions in 2 respects. First, this is no justification for singling out Assam. And second, in terms of what was recognized as the impact even then was all these border states. And therefore, this amounts to invidious discrimination and it amounts to an object which is itself by its very nature discriminatory. Now I want to just, there are several other points, but I'm just going point-wise. But I want to just leave a thought with you, and then I'll come back to it. Please consider, if you consider it appropriate, and I'll deal with this in the context, other submission. I'll just state the point and then cite the decision later. I believe this provision ought to be struck down entirely. That's my case. But please contemplate prospective invalidation. Think about, I'm sure your lordship will think about it the moment we make a submission in that regard. But I'm just planting the seed at this point of time. Look, it was mentioned correctly by, I don't know what correctly, but the Solicitor General at least at one point reacted to the observations made by the bench. I'm just saying it was a reaction. Maybe this is in the nature of a transitory provision, etc. But I'm not holding anyone to that particular expression. But surely, when you have no time which is prescribed at all for when you can take advantage of this, and if it were for some historic purpose from 66 to 71, surely it should not continue on the statute book and become a license and become an opportunity, a fertile ground for all sorts of local industries with regard to documentation and things of that sort, and remain on the statute book and remain on an endless beacon only to the state of Assam. So anyway, I've just made that point with regard to this. So I now come to my next submission. It really builds on the point regarding the communique. Territorial classifications we accept are valid classifications. That is a valid method for the legislature to certainly go about its job. We don't question that at all. The issue is is it a valid classification here when the problem was for all the border states, when the communique recognized all the border states, when the affidavits which have been filed by the union government also record and their submissions record and accept that this is a huge problem in other states as well, which are just our neighbors, then the question I ask myself is, surely this is a case of impermissible and a discriminatory object of itself, singling out Assam for this. And when it is combined with the notion of ordinarily resident in Assam and continues to be ordinary resident in Assam, it has impacts across generations and across decades. Yeah. Now I come to the next point. So I won't take you there, but the Solicitor General correctly went through his written submissions and he pointed out 6 sets of provisions in our constitution itself, which are specific to Assam. So I'll just comment on them because that was the point which was raised. The provisions which are special to Assam in our constitution are in this regard. First, with regard to autonomy and greater autonomy to certain areas, including 6th schedule. 1. That's one type. Second, it is with respect to grants being made by the central government in lieu of export duty on jute. So again, it's something beneficial. Third, it's in respect of general grants in aid to Assam, because there are parts of the country which are found to be necessitating or requiring a leg up. Fourth, there are special provisions by the GST Council for Assam and a number of other enumerated states. There are 6 or 7 states which the Solicitor General barely placed before you. So it's a group of states where it was felt that the GST Council, etc., has to have special regard with regard to Assam. Then it's with respect to provisions for reservations of scheduled castes and scheduled tribes. And the other special provision is for tribal administration. So broadly, these are special provisions inuring to the benefit of the citizenry of Assam, the people of Assam, and the state of Assam. They are not provisions where you set out one territory and then discriminate in it. When I say discriminate, what I mean is, your lordships have followed. I mean, I'm not saying there was some animus against the state of Assam, not that way. What we are suggesting to the court is, by singling Assam out and then coupling it with ordinarily resident for all times, I mean, it's really a death blow, or it's terrible as far as the demographic and future impacts are concerned. So, territorial classification we accept. All the examples given are beneficent for advantages, for certain social good and uplift. I don't believe the present statute fulfills any of those requirements insofar as the citizens of Assam are concerned. Now we have no, yes, I would respectfully submit, there is no instance of any, what I would describe as hostile discrimination. These are all beneficent classifications for Assam. There is no case, at least as which we could find, or no situation where Assam has been singled out for the purposes of something harsh or something which is disadvantageous. I'll say disadvantageous. Now I come to the next point. And the next point is really in terms of, now the reality is that this 6A is only with respect to Assam. So I'm just stating the point. I believe this by itself and nothing further requires heightened scrutiny or strict scrutiny and not the relaxed scrutiny standard which was commended by the Attorney General. I will just put it at that. Now, please, sorry. Now, please. Sorry. Yes, no, update. Statelessness. Yeah. Now, my lords, I'm on my next point. Now, here, please consider as an alternative submission on our part an appropriate declaration, strictly in the alternative from my standpoint, a declaration that the impugned provision section 6A be declared prospectively to be invalid. And here, I'll just give you the citation. The judgment that we are relying upon is Somaiya Organics. Okay. 2001, Volume 5, SCC 519. The relevant paragraphs are 23 to 27. Sorry, 20, my mistake, 23 to 37. I'll just read 37, Your Lordship. I mean, if it's there, well and good. Otherwise, 37. Okay. Yes. Nevertheless, a enacted law without legislative competence remains on the statute book till a court of competent jurisdiction adjudicates thereon and declares it to be void. When the court declares it to be void, it is only then that it can be said to be, it is non-est for all purposes. In synthetics and chemicals, the invalidity of the provisions was a declaration under Article 141 of the Constitution. It was for doing complete justice that the court, in exercise of jurisdiction under Article 142, molded the relief in such a way as to give effect to the declaration prospectively. It is not possible to accept that such an order of prospective overruling is contrary to law. An invalid law has to be held to be, and has not been held to be valid. All that has happened is that the declaration of invalidity of the legislation was directed to take effect from a future date. So this might be, I mean, just if we are wrong with respect to our primary submission, but you feel, or rather, if we are right on the primary submission, but Your Lordship feels that still there is some molding which is required to be done, then you may consider this. But according to us, it is really unfair to have this continuing on the statute book, because it's not just a one-time issue. It's an abiding impact which continues across generations. Now I come to my next point, because I understood a submission to be made that with regard to culture, there has been no explanation in either the pleadings or in any of our documents as to what it is, etc. So I'm just giving you the paragraph numbers and the page numbers, and I'll just summarize our case. In Writ Petition 876 of 2014, which Your Lordship will find at Volume 3, the no, it's 3 is okay. Volume 3, the averments as far as culture are concerned in great detail are from paragraphs 21 to 34 of the petition. And it's at pages 3010 to 3020. So we've given definitions of culture, international obligations for preservation. Sorry. Yes, yes. 682. Yes, that's a, yeah. Yes, it does. Yeah. Yeah. Right. No, but can I just tell you, at this distance, so yeah. So may I just respond to that? So I'll just respond to that. The question being put, sorry. Yeah.
Persons who would have not have been included. But still it will open to them to contend that we were there before 66.
Yeah. So I'll
Either
just
that's
answer,
it,
but the
factually that's
question,
also possible.
yeah, the question to being, as I understand it, is that is it too late in the day to provide a machinery insofar as 6A2 is concerned? That's one, I think, one part of the question. In my respectful submission, at this distance of time, which is 37, 38 years after 1985, that's why we waited to see how are they going to place their case as far as machinery, etc. is concerned. But nobody even suggests that there's a machinery under 6A2.
Actually,
So I would, sorry.
There's a little bit of a policy determination by Parliament. I think what Parliament seems to have done was that they said prior to 1966, they gave a very liberalized regime for deeming citizenship. After 66 and
It's the same
before
four criteria.
But between 60, you're right, same criteria.
Same criteria.
But with the addition for 66 to 71 of registration. No registration.
But that's included, Manoj. Please see that.
There is no registration requirement for prior to 66.
Sorry? Registration under 63. Yes.
So, therefore, for those who came in between 66 to 71, they had one specific criterion, namely that you must have been detected as a foreigner. That is, it's like an amnesty. That, first you are detected as a foreigner. If you are not detected as a foreigner, you don't get the benefit. After you're detected as a foreigner, you have to then register. If you have registered, then you get citizenship. That's the scheme for 66 to
Actually, that is how we understand it as well.
That's right.
Because it was suggested, and just to add to that, we didn't find any method by which you can make a self-declaration.
You have to be detected.
It has to be detected.
Now, prior to 66, I think there seems to be some sort of a more, should we say, a more relaxed regime which was applied by Parliament.
What does it mean?
On the basis that, these were things which happened in the past. They are not going to go out of India. You don't want them to be stateless. They have assimilated for all intents and purposes, because prior to 66 means that 19 years had elapsed even when the law was brought into force. Parliament felt that, all right, now what has happened in the past, let's now freeze it at that.
Well, I would respectfully submit that would, sorry.
Prior to 66 are.
Yeah. So just responding to the point, I would be a little more generous to Parliament, in the sense I would suggest that Parliament is certainly providing criteria which are objective. So what I'm suggesting to the court is that I believe it would be correct to interpret this statute as saying that Parliament intended exactly what it mentioned. It didn't want to just hand over citizenships XYZ.
There are those conditions even there.
There are criteria which are there. Now, if you have criteria which are there, there ought to be a machinery. So what your lordship is saying, there's not even a census. It's not even after this act comes into force that there is a count that at least we are freezing everybody on this day.
There would be a
Not even that.
There would be a machinery under the foreigners order.
No, there's nothing, my lord. Nothing happened after 1985. It's just, we specify so that nobody can really object and say it's criteria less. And then we have no machinery, so it becomes criteria less. And then there's a distance of time, so therefore an argument is advanced that delay and later. So I think we should be. Yeah, so I'm done with that. Now, my lord, yes, no, so just census figures. So 4 impacts: language,
religion, land holding,
and number 4, self-governance. Because if you're taking away vote, it's a right according to our self-governance. Organizing yourself in a community is all a very, very important aspect of culture. And what is happening here is there is an enormous undermining of the local community by, I will use the expression, non-citizens. So that's the cultural impact which we have, which we believe we have been able to satisfactorily project. None of this has been contested at all. Now I come on to the point, next point, which is with regard to proportionality and the basket of rights. Now, citizenship, as we understand it, I indicated that earlier, is a full-fledged basket of rights recognized under the Constitution, recognized under statutes. One can understand, there are subordinate rights. Those subordinate rights might involve an exclusion of political rights. It might involve an exclusion of certain economic rights.
What is that point? Subordination?
Sorry?
What is the second point?
No, so I'm just suggesting to the court that you have a full basket of rights.
Yes,
that's one. That's citizenship. But there can be situations. So, for example, let me just give you an example. International humanitarian law requires,
there are minimum standards under international humanitarian law. You have to provide that. You can't, but that is short insofar as of citizenship. So the proportionate response which could be in a situation such as this, if people have come from 1966 or earlier than 66, or because of certain situations and exigencies such as facing deprivation or facing much more hostile circumstances, then certain minimum international human rights, humanitarian law standards can certainly and ought to be extended. But that is short of citizenship. And therefore, in our respectful submission, 6A fails to narrowly tailor benefits to non-citizens.
It is completely disproportionate in what it grants and gives without any meaningful scrutiny. And so the expression used, live and let live, is perhaps consistent with international humanitarian law in the context of illegal migrants, but there is no requirement of conferring citizenship. That is something much higher. And this provision, in doing so, perhaps exceeds permissible limits. Now I go to my next point. So I will just come to statelessness, but just have a look at one provision which was read, which is the Foreigners Act. It is at page 386 of volume 4, serial number 6. There are just 2 statutes I want to touch on. Your Lordships have the Foreigners Act 1940. So I'm going to just read this, just read the section. So Your Lordships will see what can the central government do, or what is it required to do elsewhere in the country. Lordship, sir, Foreigners Act 1946.
Yes.
So if we see section 3, directly, I'll just read this. 3(1), power to make orders. The central government may by order make provision, either generally or in respect to all foreigners, or with respect to any particular foreigner, or any prescribed class or description of foreigner, for prohibiting, regulating, or restricting the entry of foreigners into India, or their departure therefrom, or the presence of continued presence therein. In particular, and without prejudice to the generality of the foregoing power, orders may be made under this section that may provide that the foreigner, A, shall not enter India or shall enter India only at such times and by such routes. B, shall not depart from India or shall depart only at such time and by such route from such port. Shall not remain in India or in any prescribed areas therein. Shall, if he has been required by order under this section not to remain in India, meet from any resources at his disposal the cost of removal from India. D, shall remove himself to and remain in such area in India as may be prescribed. Shall comply with the conditions as may be prescribed or specified, requiring him to reside in a particular place, imposing any restrictions on his movement, requiring him to furnish such proof of his identity and to report to such particulars to such authority, requiring him to allow his photograph and finger impressions to be taken, requiring him to submit himself to such medical examination, prohibiting him from association with persons, prohibiting him from engaging in activities of a prescribed or specified description, prohibiting him from using or possessing described or specified articles, otherwise regulating the conduct in any particulars as may be prescribed, shall enter into a bond, etc., shall be arrested and detained or confined, and may make provisions for any matter which is or may be prescribed, and for such incidental and supplementary matters. So very wide. Now, this is the regime which applies across India for foreigners. This is their power which they have. And please see subsection 3. Any authority prescribed in this behalf may, with respect to any particular foreigner, make orders under clauses E, F of subsection 2, which, as your lordships have seen, includes the removal, requiring a person to reside in a particular place, etc., and to enter into a bond, etc. So now this is the national regime. So they have these powers, and I think the purpose of this section is also to draw the distinction between citizens on the one hand and foreigners on the other hand. So there's a divide, and there is a huge gap, therefore, in lifting up to a citizen. Now, please see the other provision which was read to your lordships is the Immigrants Expulsion from Assam Act 1950. Now, look at this statute. It's at page 424 of volume 4, and it's at serial number 10. Same volume.
Immigrants Expulsion from Assam.
1950. The Immigrants Expulsion from Assam Act 1950, which was placed in court.
Page? What page should that be?
424. Volume 4, page 424. Now see the parliamentary mandate here. An act to provide for the expulsion of certain immigrants from Assam, be it enacted by Parliament, short title, the act may be called the Immigrants Expulsion from Assam Act 1950. It extends to the whole of India. Power to order expulsion of certain immigrants. If the central government is of the opinion that any person or class of persons having been ordinarily resident in any place outside India has or have, whether before or after the commencement of this act, come into Assam, and that the stay of such person or class of persons in Assam is detrimental to the interests of the general public of India or any section thereof, or any scheduled tribe in Assam, the central government may by order, A, direct such person or class of persons to remove himself or themselves from India or Assam within such time and by such route as may be specified, give such further directions in this regard to his removal or the removal from India or Assam as it may consider necessary or expedient. And then the proviso. provided that nothing in this section shall apply to any person who, on account of civil disturbance or fear of such disturbance in any area now forming part of Pakistan, has been displaced from or has left his place of residence in such area and has been subsequently residing in Assam. So I'll just make 2 or 3 submissions. First, where the expression in section 2 is the central government may by order direct the person to remove himself, we would respectfully submit this is a power coupled with duty. That's one point I want to make. So the whole emphasis is that you have a parliamentary statute which is extant for expulsion of people from here. And on the same hand, how do you balance that with section 6A and this open-ended no time limit provision which continues to act as a beacon? So the two really don't stay or can't really sit side by side. And here, if we are correct that this is the act which really should be worked and its main purpose is expulsion, then I would respectfully submit that as far as the proviso is concerned, it has to be given its plain meaning, but it's a narrow exception to the general rule. It's a narrow exception insofar as the general rule is concerned. Yes, and this again, my lords, there's no question, of course, here of conferral of any citizenship. Now, my lords, I just want to point out one part with regard to one other element, and this is in our writ petition. I'll just give you the page number. It is page 3044, volume 3. I am just mentioning this because it came up in the course of your lordship's observations, etc. There's an extract here from Dr. Namrata Goswami, who's an associate fellow at the Institute of Defense Studies and Analysis, New Delhi. And she has written a paper or a study. And there is a quotation here, which is important from a facet which your lordships raised, which is economics. Because the state has limited economic resources, and what is happening as a result of illegal migrants is that there are manifold economic impacts which are recognized here. So the labor law, the labor rates, etc., go down. And the result is that local people don't get as much of a living as they might otherwise. Then there are beneficent schemes which the government of India rolls out, and those resources also get drawn up by persons who ordinarily would not be entitled to it. Now, my lords, I go to my next point, and the next point is with respect to this notion of statelessness. Now, I'll just make 3 or 4 points on statelessness. I gave it. Oh, sorry, the whole document is also available. I have to give it.
That issue, statelessness, doesn't arise here, my lord. It arises in somewhere else.
No, but my lord, they've argued on statelessness, and that has weighed heavily with your lordships. That I want to just address your lordships on statelessness. I'll just make 4 points or 5 points. First point.
There are other petitions pending on this, my lord. Therefore, I am cautioning my learned friend as a good friend, my lord, that let him not touch this issue. My lord. Nobody has raised it.
No, but it's a concern which your lordship, the argument made is that if you strike down 6A, it will result in statelessness. I'm only meeting that argument and nothing further. I'm not going beyond that. The argument of the respondents was that please don't strike down section 6A. That's how I understood the argument. We will be rendered stateless and there'll be... So I'm just answering that. First point, this argument of statelessness is completely unjustified. And the reason we say so is because, number one, what is the regime which applies across the country other than Assam is the question I ask myself. The very same regime which applies across the country doesn't result in statelessness will apply to Assam if we are correct and this provision is struck down. That's number one. Number two, nobody is asking for consequential reliefs in some summary manner. We are only seeking today a suitable and appropriate declaration of the law. The declaration of the law will not result in by itself. It will just state what the correct, it will clarify the correct position in law. What consequential provisions are to be, action is to be taken will follow from that once we have the advantage of your lordship's ruling. But to hold up statelessness and say that, oh, if 6A goes everything, I don't believe that there is any justification at all for that. Now, this takes me to the latest affidavit they have filed. Now, please just go to that affidavit. The new affidavit. Please go to page 2, paragraph 4. I'll just focus on a couple of paragraphs. You may, sorry. Your lordships have the affidavit?
Yes.
So you may just consider on the 7th December order, I think in clause Roman 1, perhaps it should be 6A3. You may, I mean, if you find that as an error, then that just may be.
Mr. Devan, after this affidavit, you will wrap up because then can you...
Yes. No, I'm wrapping up. Yeah. So I'll just make 2 points over here, or 3 points. So that correction if you want. Now just see para 4. That with reference to query 1, namely the number of persons to whom citizenship has been granted under the proviso to 6A, I think it should be 3, namely persons who who came to Assam between 66 and 71, it's humbly submitted 17,861. Your lordship has that figure. And the next figure is, which is that the foreigner, that with reference to the query, how many persons have been detected to be foreigners by an order of the Foreigners Tribunal under the Foreigners so-and-so order 64 between 66 and 71, the answer is 32,381. So the first issue, which I'm just stating the point, is what happened with regard to 32,381 less
17,861. So that works out to 14,520 persons. So they must inform the court as to what is the action which has been taken in respect of these 14,520 persons, because these people are found not to be entitled to any right even under 6A3. So I would respectfully submit. So this is one important point which your lordships will consider. What is the action taken with regard to that? And then please see 6AA, para 6A. Illegal migrants enter into the country without valid travel documents in a clandestine and surreptitious manner. The detection, detention and deportation of such illegally staying foreign nationals is complex and an ongoing process. So when your lordships asked them for the estimated flow, this was the answer. Now the bottom line is, there is no authentic information with regard to when the 1985 Act came, who is going to benefit or how many are going to benefit under 6A2. There is no authentic figure even in respect of 6A3 because it is open-ended in terms of time. And we would respectfully submit that insofar as the notion of statelessness is concerned, it is just being raised without, because we ourselves say that as far as international humanitarian law is concerned and that proportionate response is concerned, that's the obligation of the state. We are not for a moment seeking to prejudice anyone in that behalf.
I'm on my last point. And the last point is with regard to delay and leaches. Now, I'll just very, very briefly tell your lordships 3 or 4 issues. First, you will find the reference order itself has gone into this issue inter partes. That's one. And I said that we are entertaining this petition. So it's inter partes between the same parties that a determination has been made by this court. So we're not sitting in appeal over that judgment in the very same case. So that should bind. But the reference court left it open to your lordships to mold the relief appropriately. So that's my first point. My second respectful point is that if they accept, as they do, that this provision continues to operate and even tomorrow you can go and apply under 6A2 and 6A3, then in our respectful submission, there's no question of delay and leaches because it's continuing in every respect. My third respectful submission is that you have a situation now which is the aspect regarding culture, community, economic rights, which extends generation upon generation. So it serves and deserves to be struck down if we are correct. Even today, to protect what is left, despite this huge onslaught on our cultural and community rights. I'm very grateful. Thank you.
Thank you, Mr. Thank you, Mr. Diwan.
Please, Your Lordships. Lord, the first point I would like to deal with is regarding the delay, my lord. On the point of delay, my lord, as my learned friend Mr. Diwan has pointed out, my lord, in para 31 of the referral judgment, my lord, virtually, my lord, this point has been rejected. And I'm sure this is not Lordship is not sitting in appeal over the reference court's order. Therefore, my lord, as far as the issue of delay is concerned, that stands at rest.
Yes, the reference court did frame one issue, my lord, in view of the fact that these beneficiaries have enjoyed certain rights over a long period of time. Therefore, what views this honorable court should take at this stage? In other words, my lord, it is in the relief mode of, my lord, molding of relief.
Then to non-suit the petitioners, as the other side would like to contend. Therefore, my lord, in my written argument, my lord, I think at page 29, I have dealt with this issue, my lord, in details, my lord. I may indicate, my lord, which are the pages.
That's all right. You've told us earlier. We'll find it out.
My lord.
Just summarize now what you want to say.
Yes, my lord. Lord, kindly give me 15 minutes time, my lord. My lord, page 29 to 32 of my written argument of volume 1, my lord. Now, my lord, the government's affidavit, which they have filed, my lord, government is trying to give an impression that what we are agitating is a trivial issue. It's a matter of 30,000 or not business. So what is great in it, my lord? With all respect, I'll submit, my lord. Is it the case of the government? They're considering this litigation to be an adversarial litigation, where, my lord, millions of, my lord, immigrants are in the state, where the local people have been outnumbered, and government would still like to go by legalism. With great respect, my lord, this cannot be the correct position, my lord. Now, my lord, yes, it is a fact. It is very difficult to make approximation as to what is the exact extent of immigration which has taken place. That's very difficult, my lord. The white paper published by the government of Assam also expressed the same difficulty. But, my lord, there are contemporaneous facts from which one can come to the conclusion that this immigration is of substantial, and, my lord, it has caused change of demographic profile and other adverse effects, my lord. First, my lord, I would like to place, for your lordship's kind consideration, in the rejoinder submission, my lord, I have volume 1A, my lord. If your lordships will kindly come to page number 3.
Don't you do this like Mr. Diwan had formulated? In fact, I've taken
No, I'm formulating
14 submissions of Mr. Diwan. Now you just formulate point and then tell us what the, because we are now in rejoinder.
No, I know, my lord. What I'm trying to say.
So first is
my lord, while opening also, my lord, I couldn't get much of time.
So delay, you have said that, you know, the reference judgment para 31, volume 1, pages 29 to 33.
I have dealt with that issue, my lord.
All right. Now what is the second submission?
My second submission is, my lord, I'm trying to, my lord, take a stand against the affidavit filed by the government.
So tell us the submission, formulate it now.
The submission formulate is, my lord, the extent of immigration is much more, my lord, than 32,000, the figure which has been reflected in the affidavit.
So in this regard, my lord,
But that really doesn't affect the validity of section 6A.
what I'm saying,
Because assuming that the immigration is not 32,000 but 3,20,000 or 32 lakhs, the number of persons who are granted citizenship doesn't vary.
it has a bearing, my lord, according to us, subject to what your lordships may say. I'm coming to that. I'll come to the parliament's plenary power also, my lord. What are the limitations of that also?
All right, extent of immigration is more than 32,381.
No, much more, my lord. It is much, much more.
All right, what is the next?
No, my lord, I'd like to place two paragraphs. Kindly permit me at page 3 of my volume 1A, my lord.
Volume
1A.
Volume 1A.
Of the rejoinder submission. My lord, is second subpara 2.
Page?
Page 3, my lord.
So what is the point you make that don't read
Point
it?
I'm trying to make is the Law Commission in its 175th, report on amendment of the Citizenship Bill, my lord, 2000 said that the immigration is of such an extent that it has the potential of, disturbing the unity and integrity of the country. It poses serious security threat to our democracy.
But are you saying that the number of persons who are granted citizenship under section 6A
yes,
is more than 17,000?
Millions, my lord. It will be more than millions.
How can that be?
My lord,
You're
my lord,
confusing.
as far as
Conflating persons who are illegal immigrants with those who have been granted the benefit of citizenship between 66 and 71.
No, my lord, regarding the first batch of from up to 1166,
Right.
then there's a second batch where only they would be, my lord, defranchised for 10 years after they follow the procedure.
Right.
That's the position.
Right.
And my lord, after 25/3/71, these people are to be deported in accordance with law. That is what the, my lord, accord is all about, and that is what section 6A is all about. Now, my lord, by conferring citizenship to this stream of people, my lord,
the first batch.
Yes, my lord, security of our country has been endangered. That is what Law Commission says. That is what, my lord, the group of ministers also says. I'm trying to rely on those, reports of the government of India. So, my lord, Law Commission clearly says, Law Commission noted that entry of Lordships will kindly.
You said says that there's a potential to disturb the integrity and security.
Yes.
All right,
And that was an aspect which was taken note of it. And the next point is, my lord, after the Kargil war, the then Prime Minister of India constituted a committee or a group of ministers.
That's not a point. That's material. What is the point that you're
making? The point which I'm trying to make is, my lord, the recommendation or the report of the committee reveals that there are, my lord, 12 million foreigners in northeastern India, and the report reads like this, my lord.
Where is the report?
At page 3 of volume 1A. Report is at the report is at, my lord, page 3 to
Mr. Chaudhary and Mr. Hansaria, we are not going to extend hearing beyond 4 o'clock today.
Yes, yes.
Today we close.
My lord.
Whoever has not finished, whoever has finished, there's a guillotine at 4 o'clock today.
Yes, yes. No, my
lord. So, no, this will not spill over to tomorrow because we have another CB tomorrow. So, you've got about 34 minutes between the two of you.
Yes.
So please ration time and
my lord,
between.
we'll share amongst us.
No, the last batsman can hit a first ball 6, you see.
No, my lord. No, my lord, run
required. The others are scared of getting out, so they don't try to hit a first ball 6. The last batsman knows that he can hit a 6 and there's nothing to lose.
The run required is 45 and only 2 overs is remaining. It's a difficult task. Anyway, my lord. My lord, the report is at page 3242 to 3351 of volume 4.
3242
23351 of volume 4.
All right.
It was headed by the then Home Minister of the country, my lord. And the relevant report which I would like to read, my lord, is para 2.35 at page 3254.
Para
2.35
at
page 3254.
all right.
And just a small paragraph.
Just tell us what it said. Don't read out. Just tell us, make the point. We'll
It
read
says,
later.
my lord, there are estimated to be about 12 million foreigners in Northeast. A host of problem has been created, including, my lord, economic, political, communal tensions, ethnic classes. And one very significant observation regarding Assam was, my lord, 32% of the constituencies in Assam are dominated by these illegal immigrants. That means out of 126, 40 seats. Their vote is decisive in 40 seats.
One 126 constituencies, no?
Out of 126, my lord.
40.
32 makes it 40 point something. So it's 40. So therefore, my lord, in my humble submission, figures do matter.
Right. What's the next point?
Yes. Now, my lord, my friend Mr. Sival has mostly covered the points, my lord. Therefore, I will not repeat. I would like to emphasize on a particular point, my lord.
Yes.
What is the scope of Parliament's plenary power? Are we to understand it admits of no limitation?
Just formulate it so we
The
can.
formulation is, my lord, the power, plenary power of the Parliament, its scope and limitations.
According to the plenary power of Parliament, is subject to limitation.
Yes, my lord.
Of course it is.
Yes. Now, my lord, from the facts which I have referred just now, my lord, what emanates according to us, my lord, subject to what your lordships may say, that making of this classification and creating this class of deemed citizens is posing security threat to this country.
That you've already said.
Yes. Therefore, my lord, as per the decision of the Honorable Supreme Court in Indira Nehru case, my lord, versus Rajnarayan, where Honorable Supreme Court says that amongst others, my lord, supremacy of the Constitution and unity and integrity of the country are also basic features of the Constitution.
All right.
Now, if granting of or conferring deemed citizenship to this class of persons, my lord, it poses security threat, is the object of the legislation not unlawful? Therefore, would the Parliament's power be not fettered by, my lord, the constitutional inhibition of violation of doctrine of, my lord, basic feature?
Yes.
Therefore,
Yes, Mr. Dev.
my lord, in R.C. Podwal's case, the
Formulation. What is
Yes.
the formulation?
now the formulation is, my lord, classification has resulted in creation of a class of citizen who pose security threat, which in turn would impair the nation's unity and integrity.
That point you've already made.
Now, my lord, here, my lord, I would like to refer on the judgment of the Supreme Court, of this Honorable Court, in R.C. Podwal's case, my lord. In R.C. Podwal's case, my lord, the question which arose was,
Bhutia lectures.
yes, what is the, the non-obstante clause,
Though they have 20% of the population, they had reservation of 38% of the seats.
and
in
one of
Assam.
the one person, one vote, that principle was also, my lord,
But
done
that
away
was,
with.
that was rejected by
Yes.
Chief Justice Venkatachala's judgment.
Yes, my lord. No, no, what I'm trying to say is, my lord, I'm relying on paragraph 102, 175 and 176. 102 is by majority, my lord, and 176 is by judgment, by Honorable Justice Agarwal, my lord. Now, what I'm trying to, submit for Lordship's kind consideration is, the meaning of that non-obstante clause was, laid down, my lord. Now, issue was whether, in view of the non-obstante clause, while exercising power under clause F, they can undo the constitutional inhibition, my lord. There, this honorable court said, my lord, that no. Yes, the non-obstante clause would permit you to undo some of the constitutional provisions, but if it goes to the extent of overreaching or overriding the basic features theory, then it will be bad. Now, what I am trying to, the support which I seek to draw from the judgment is, my lord, by conferring citizenship right
Yes.
to this section of deemed citizens, my lord, the security and integrity of the country has been endangered. Therefore,
You made this point 3 times, Mr.
no, therefore the object of the legislation is, my lord, something which cannot be countenanced.
Thank you, Mr. Jodh.
Just one more point.
At 3:18, you said 15 minutes. It's now 3:34. So you've got 1 minute now. Almost 3:35 now.
All right, finally, my lord, I'll just urge one more point, my lord. Government of India very candidly says, my lord, that as far as the allegations we have brought out in the petition or the averments which were made in the petition regarding, my lord, the adverse effect of illegal immigration, they accept it. Is it not the government of India to do something, my lord? What have they done? While opening my argument, my lord, I made a submission based on Article 355 that it is the duty of the central government to protect the interest of the indigenous people of the state. Lordship would recollect, while upholding Armed Forces Special Power Act, this Honorable Court had taken the view that Article 355 enables framing of a statute like, my lord, Armed Forces Special Power Act, where a non-commissioned officer, even a junior commissioned officer can, my lord, without warrant, even act in case of a non-cognizant.
According to you, government has not done anything that it accepts the impact of illegal
Yes,
immigration.
therefore they can't, my lord, accept the thing and at the same time not do anything. And on the contrary, coming up with these figures, my lord, to show as if it's a trivial issue. It's not a trivial issue, my lord. It's a very serious matter. Finally, my lord, I'll make one submission for Lordship's kind consideration.
But actually,
in the event,
they have not said that illegal immigration is a trivial issue. They are in fact saying it is a very serious issue. But they say that we can't give you an estimate. It is so large. I mean, and it's impossible to give you an estimate because they are all people who are clandestinely and surreptitiously in India.
If that is the position, absolutely correct, my lord. There's no difficulty.
That they're right also because they are not disputing the fact that it's a very serious problem.
Yes. And Lordship, as I have already submitted, Lordship will also consider the aspect.
Nor are we for a moment even suggesting it's not a serious problem. Undoubtedly it is.
In that case, they ought to come up with a more stringent law as to how to deal with these foreigners instead of conferring them citizenship, my lord. It's an unheard of concept anywhere in the world. Where, my lord, own citizens are at the risk of losing their identity. They are protecting the, my lord, foreigners, don't protect them.
That point you have made.
Yes. Now, finally, my lord, having regard to the lapse of time, the numbers, we all appreciate, my lord, the practical difficulties. In the event your lordship is inclined to take the view that we will not strike down 6A, there my submission would be, my lord, let the post 19748 stream of people be identified and let them be, my lord, relocated in these different states on pro rata basis. Why Assam alone should, absorb this disproportionate burden?
Even if section 6A is not struck down, the post
748,
1971.
yes, stream of people should be identified by undertaking an exercise like NRC, and my lord, relocate them to different states on pro rata basis across the country. If there is an humanitarian angle, if there is an Article 21 obligation, certainly these measures can be certainly adopted by the state, my lord. Why Assam is a very small state, my lord? The land mass is also very less compared to other big states. So therefore, my lord, why not? They should also on pro rata basis, they should be relocated in the other parts of the state.
Yes, Mr. Ansaria. Thank you.
Let me start with the disadvantage being the last investment, my lord. Lord, before I formulate, my lord, the Chief Justice asked a very pertinent question to Mr. Diwan. When he was arguing clause 2, deemed section, my lord, Lordship said the Constitution also provides Article 6 a deemed provision. Section 6A2, clause 2 says, my lord, deemed if it before 1/1/1966, no exercise is necessary. My lord, the Chief Justice said there is a Constitution also provided deemed fiction under Article 6, my lord. Would your Lordship kindly see, my lord, Article 6 for a minute, my lord. It has limitations, my lord. If your Lordship see, my lord, Article, just give me mine. The Lordship give me, not mine. Yes, sorry. It is something happened. If your Lordship see section Article 6, my lord, A, Article 6B2, which gives citizenship, my lord, to the persons who have migrated after 19 July 48. There are 4 criteria, my lord. Because, my lord, here also they are giving citizenship to the persons who have come after 19 July 48. They have to be registered as a citizen. They have to make an application. They have to make that application before the commencement of the Constitution, before 26 January 1950. And they have to be in India 6 months before. None of these conditions are there in clause 2, my lord, of 6A. It's open-ended. Mr. Diwan, I said it's open-ended. Today also I say, my lord, I came before 1966. Constitution Article 6B2 does not permit that, Lord. You have to make the application before 26 January 1950. And you have to make an application. That application, Lord, so there's a fundamental distinction between clause 2 of section 6A and Article 6B2 of the Constitution, Lord.
6B2 came in because there was a permit system, as Dr. Ambedkar said.
Here also, that's what I'm saying, Lord. Here also, so far as 6.3 is concerned.
On 19 July 1948.
I'm coming to that. Lord.
It's a product of
Lord, that's what I'm saying. 6A3 says you have to apply. But so far as 2 is concerned, my lord, you are shifting the date, my lord. My first argument that you are shifting the date from 19 July 48 to, my lord, the 1st January 1966 by this legislation, my lord. You can do a 368 route. This argument will not be available to me, my lord. But by parliamentary legislation, you are shifting the date from 19 July 48 to 1st January 1966. And without those riders, which are there, you're making it open-ended. Even today, wherever there is, there was a time limit of 26 January 1950. Make an application so that people can authenticate, on that day. So that's a fundamental distinction, which my lord, the Chief Justice pointed out, And my submission is that 6A2 and Article 6 has a completely different scheme.
All right, then.
My lord, with this, may I just respectfully submit that draft constitution contained Article 5 and 6 only, which translated into Article 5, 9, and 11. It did not have Article 6, 7, 8, and 10, which were introduced during the debate by Sri Ambedkar, Dr. Ambedkar, on 10th August 1949 by way of 5A, 5AA, 5B and 5C. And my lord, the debates which my learned solicitor read, my lord, in my respectful submission relate to the draft articles 5 and 6. There's a different debate and lord, expression of opinion by all the three learned eminent members of the Constituent Assembly on 5A, 5AA, 5B and 5C. And my lord, our is, my lord, regarding 5A and 5AA, which is Article 6 and 7. If your lordship kindly see that, lord, it contains a complete code. I'll invite your lordship's attention.
Mr.
Yes.
What is the?
No, my submission is, my lord, that the submission of the central government, the learned solicitor, that the parliament was given due leverage to extend and amend under Article 11 does not apply to the persons who come under 6 and 7, that is the migration from Pakistan. And there is a clear distinction drawn by all the three eminent members of the Constituent Assembly in the debate. And I'll show to your lordship, it's from the debate only, my lord. What has been read to your lordship, my lord, relate to general powers of the parliament, no dispute. But not, my lord, those were covered by Article 6 and 6.7, which is Article 5A and 5B AA draft constitution. Would your lordship now kindly see, my lord, if this preface, volume 4, the debates, my lord, page 887.
You made that point.
No, Lord, would your lordship, please permit me to read that.
Not read
It
now.
goes.
No, we are at the.
No, my lord.
Mr. Hansaria.
Yes, my lord.
You must understand, you are in a rejoinder.
My lord, I'm in the rejoinder, meeting the argument of the learned.
You made the point in your opening
my lord,
that look, these people, you have taken 25th March 1971.
My lord.
On 25th March 1971, they were citizens of undivided Pakistan.
They were Pakistan.
The liberation takes place much later.
Yes.
Therefore, you can't confer on citizens of Pakistan any provision which is beneficial by virtue of the power under Article 11A, under Article 11, which is at variance with the date of 19 July 1948.
Lord, what I'm saying is,
because
I'm meeting
19 July, according to Article 6, is comprehensive in its sweep and coverage of those who emanated from Pakistan.
I want to show that from the speeches made by the learned three eminent authors, my lord, because my lord, the argument.
Have you put it in your written submission?
My lord, I have, my lord. May I just
take it as read? We will read it later.
My lord, may I just say this, my lord?
Why don't you go to the next point?
My lord, I will not be doing justice to, my lord, my brief and.
Don't worry, we are here to do justice.
My lord, may I just say, would your lordship, this is my lord main submission. Would your lordship just permit me to show 2 or 3 things, my lord, because the submission has been made by the learned solicitor that the due latitude were given by the, and from the speeches made by the Dr. Ambedkar, Alladi Swami and my lord.
Student Assembly debate. We can't control the language of the provisions. So we got your point. You made that point right in the opening, that Article 11 cannot give leverage to Parliament to expand on the ambit of those who are granted citizenship by Article 6 and 7. That's what they have done.
That is what the founding fathers said, my lord, in the debate.
But we have to, it's a point worth considering. We'll consider it.
My lord, I'm no doubt about that. My lord, what I'm trying to say, my lord, when extensively debates were read to your lordship, my lord, it was said the parliament has been given complete leverage, my lord. The three, my lord, eminent speakers, Dr. Ambedkar, Alladi Krishnaswamy and Kunzuru's statements were read to your lordship. I want to read, my lord, they were in the context of Article 5, 9 and 11, not in the context of, my lord, 6 and 7, which are draft articles.
All right.
My lord, they specifically said, my lord.
We have noted it now.
We have noted, we will read.
My lord, may I just give the page number then?
I just give us the page number.
May I give the page numbers? My lord, Dr. Ambedkar's speech starts from volume 4, page 887. Regarding this, my lord, Article 5A and 5AA is, my lord, at page 892 and 893. In which, my lord, may I just only.
Now, just give us Dr.
Dr. Ambedkar.
Sir Alladi.
My lord, Dr. Ambedkar said on 5A and 5AA at page 890 and 893.
Just give us
and just one sentence, my lord.
Just give us Sir Alladi's.
Alladi question from me, my lord. The relevant, it starts at 953 on the same volume, which is on 12th August. 953 start, the relevant is 955.
All right.
And Pandit Kunzuru's speech starts from 961. What is read to your lordship is 961. And the relevant on this 5A and 5AA is 962 and 964. And my lord, he clearly says this is extraordinary provision, nowhere available in the world. We are making it for an extraordinary situation like this has happened, and up to 1948 only. My lord, can the parliament extend the date, my lord, from 1948 to 66 or to 71? And all the three learned speakers, my lord, who are founding fathers, and they're the heart and soul of the entire constitution which they made, my lord.
All right, you've made your point. Now, what is the next point?
My lord, I think, my lord, if a lordship, my lord, I will cut short another point. Let me read one or two paragraphs from this.
All right, read your point. You're 12 minutes short of rising time.
I will try to do, my lord. That's I say the handicap of the last batsman. 962 to 964, yes, my lord.
Yes.
My lord, may I just read 955 for a minute, my lord? (955), volume 4, my lord. This is Alari Krishna Swami Ayers explaining 5A.
Yes.
5A is intended to provide for all cases of this mass migration, if I may use that expression, from Pakistan into India, and to provide for that class of persons who have made the present India as their home. I'll skip to that note. Certain safeguards are provided for clause 2, so as to make it quite clear that the authorities cannot accept migrated people as bona fide citizens of this country. That is the object of the clause. This is the provision to the effect that no registration shall be made. Similarly, it requires a registration as shown to a lordship, Article 6(2)(b), B2, unless the person making the application resided in the territory of India for 6 months. So there are two safeguards. There will be registration. There will be no registration unless the applicant has resided in the territory for 6 months. If 5A stood by itself, it would mean that even if person went to Pakistan with deliberate intention of making Pakistan as their permanent home and remigrate to India, they might be entitled to 5A. In order to provide such a contingency, 5A is provided, then quoted, which is now Milot 6 proviso. There is no 7. There is no use of dealing with the subject if a person is deliberately and intensely chosen to be a citizen of another country. After question has arisen, after Pakistan has been declared territory independent from India, then there is no point in conceding the citizenship to such a person. But this proviso takes note of this important effect, etc., etc. So, my lord, clearly deals with, my lord, what is to be, my lord, these are the extraordinary provisions, my lord, which has been said. And 962, my lord, Pandit Kunjru says, last 3 lines of 962 and 963. Now, 962, my lords, which we can kindly go. Last paragraph. Now I shall come to Article 5A. In this article has happened occupying the intention of the members since yesterday. It has been criticized on the ground that provisions undesirable, wide flow, open to the doors of citizens who have no moral right to be regarded. I do not personally agree. Because, let us consider calmly what 5A, that is Article 6, lays down, and the circumstances which require that such an article should form part of our constitution. Article 5A and 5AA, that is Article 6 and 7, contain extraordinary provisions arising out of the present extraordinary circumstances, arising out of extraordinary situation created by the partition of India. You will find no counterpart to them in the constitution of any other country. Then, my lord, they say that there are conditions which are prescribed. Now, my lord, Section 6A does away with all the conditions, my lord, with the founding fathers tried to justify for 6 and 7, Article 6 and 7. So far as pre-66 is concerned, no condition, no requirement. Which the founding fathers thought even 48 requires, my lord, and 50 requires. So, my lord, to say that, my lord, the founding father gave untrammeled power to the parliament to make law under 11 is not correct, my lord. These observations does not apply, or the statement does not apply to the extraordinary provision made under 6 and 7. That's my first submission, my lord. Second, my lord, lordship would kindly see the constitution, my lord. Article 7 starts with the non-obstant clause against 5 and 6. Article 6(7) says notwithstanding 5 and 6. And 6 says notwithstanding 5. So 7 takes precedence, my lord, and then 6, then 5. If your lordship kindly see that, my lord.
Yes.
So, my lord, if 7 is to be given precedence, that fixes the cutoff date as 1st March 1947. So anybody who has come to India, my lord, after going to Pakistan, after 1st March 1947, he does not get citizenship. Under 6, my lord, he gets his citizenship up to 48. And thereafter, my lord, he has to go by the registration and application, etc., etc. Now, my lord, the section 6(a), 2 and 3. Mr. Diwan is there. So far as 2 is concerned, there are four requirements, my lord. And unending requirements. Even today, there is no cutoff required date, my lord, for that. 6(a)(3) requires 2 more conditions, my lord. That is, he must be detected to be a foreigner by the Foreigners Tribunal, and he must apply for registration. Now, would your lordship kindly consider it, my lord, saying that as per the affidavit of the Government of India, 30,000 and odd has been detected to be foreigner till date. So it must, my lord, it cannot be open-ended. It must confine to those 30,000 and 30,000 alone. It cannot be, my lord, millions. But till after, in case your lordship is to held, my lord, 6(a) to be valid. My submission is, my lord, the 4 conditions which Mr. Siwan has said. And that is what I have said in my rejoinder submissions, my lord, which is circulated to your lordship, my lord. Those 4 conditions, plus he must be declared as a foreigner, my lord, by the Foreigners Tribunal, plus he must make an application, and this must be confined to the 30,000 people, my lord, because till today, my lord, 30,000 people has only been detected to be foreigner. Can it be said after 100 years, my lord, it become 3 million? Would your lordship kindly see, my lord, that written submission of mine, my lord, which you have circulated today, and in paragraph 9, my lord. Paragraph 9. Just 1 second, just. Para 3. If they have not been detected till date, my lord, where is the question of granting them citizenship, my lord, up to the millions of people? As Mr. Chaudhary has said, my lord, it is an apprehension, it has happened. So lordship would confine in your judgment, my lord. That's what would your lordship kindly see, my lord, para 3 of my rejoinder submission circulated today, which is there before your lordship's screen, my lord. Six conditions. Right. Para 9, para 3 and para 9. Which says not the 6 conditions are mentioned in para 9. And my lord, I have submitted that thus the grant of citizenship to the person entering India after 1948 must comply with the mandatory this condition. It is submitted that the section 6(a)(2) required explicit. And my lord, the Government of India said 30,000, so it must be confined to those 30,000 people and not beyond, my lord. That's our submission before lordship, my lord. Next submission before lordship is, my lord, the Attorney General, they have the plenary power, my lord. No doubt they have the plenary power, but it is not, my lord, if your lordship contradict this, my lord, see this Article 4(2) for a minute, my lord, and contrast it with Article 11. 4(2) says, my lord, no law made under 4(1) shall be deemed to a amendment to the Constitution. But Article 11 does not say so, my lord. So whatever law you made under Article 11 or 246 entry 11, my lord, must be consistent with other provisions of the Constitution, which would include 6, 7, Article 14, etc., my lord. And there are 10 provisions, my lord, of the nature of Article 4(2). If your lordship kindly see Article 4(2) for a minute, my lord. It says, my lord, no such law as aforesaid shall be deemed to be an amendment to this Constitution for the purpose of Article 368. For a minute, my lord, kindly, lordship, may kindly see. And my lord, there are such 10 provisions, my lord, which is in my written submission. Paragraph main written submissions, my lord, volume 1, page 146, your lordship would find. There are 10 provisions in the Constitution which says law made under this foregoing provision shall not be deemed to be an amendment to the Constitution. And that's not, my lord. So if you cannot amend, my lord, the Constitution by this circuitous method, in your lordship's yesterday's judgment, 370, paragraph 390, my lord, the Chief Justice has said, my lord, you cannot use 367 method to change 370. This is the same thing, my lord. You cannot use the circuitous method of a parliamentary legislation to amend the Constitution, which we can do only under 368 route, not the 346 route, my lord. So that's my next submission before your Lordship, for your Lordship's consideration. Just, huh?